May I please, my lord?
Yes.
My lord, I beg to mention item 7, my lord. Here, my lord, I need some instructions, my lord.
Number 7.
7. Supplementary hearing, my lord.
You are for the petitioner.
I am for the petitioner, my lord. On other side, my lord.
Right, Mr. Rinku Soikia, I came for the petitioner. Heard Mr. Indranil Chaudhary, the learned Advocate General for the state of Arunachal Pradesh. Mr. Soikia prays for some time to take instructions. The learned Advocate General does not have any objection. Therefore, the hearing is adjourned today. When do you want it?
On 5th May, my lord.
On 5th of May.
5th of May. Is this matter on 5th of May for hearing?
All right.
Number 1.
In item number 2, pleadings are complete. But in item number 1, this is a new matter. Here, my lord, if your lordship peruses the first order, the question of maintainability was to be taken up.
Yes.
Right.
So, it should be disposed of first, I think.
Maintainability has to be taken up.
Maintainability has to be decided.
May I please, madam?
Yes.
Because I am actually not feel well. So today I am not in the position to argue the matter, my lord. So this is the same matter in item number 2 also, my lord. Similar matter, my lord.
Since the other matter is fixed on 5th of May, let this also go to 5th of May.
Same.
In the meantime, my lord, if necessary, we'll file an affidavit raising the question of maintainability.
Yes, sir.
Right, Mr. N. Taje.
Yes, my lord.
Appearing for the petitioners. Right, Mr. Indranil Chaudhary, the learned Advocate General for the state of Arunachal Pradesh. Mr. Taje submits that today he is not in a position to argue this matter
5th May.
and prays for an adjournment. Mr. Chaudhary does not have. Therefore, the matter is adjourned today. List on 5th of May. To hear the parties. List on 5th of May. The respondent shall have the liberty to file. Respondent shall have the liberty to raise the issue of maintainability of this petition. So list this matter on 5th of May. 5th of May. 5th of May. Along with item number 2.
All right, my lord.
Item number 3 and 4.
Lordship, before I take you to my pleadings, I would like to briefly introduce the matter and also point out a very simple approach to disposing this off. Lordship, this is a matter concerning a power transmission line and compensation for land duration thereof. What the state did is that they took out a notice in 2023 regarding the reserved forest portion of the area that was under the transmission line. And it said that for the reserved forest area, a compensation to 50% of the normal compensation will be payable to persons who are affected but do not, I'm sorry, Your Lordship, but do not have any right to such compensation. The Lordship, we came in a writ, and the single judge decided that no, this is an extra favor that is being done by the government, and it is for people who are not having any rights. Our contention was that people who do not have any rights cannot be given any compensation under the Telegraph Act and Electricity Act. The contractor, the authority which is setting up the transmission lines is by law made responsible for compensation only to affected parties, and that too in full as specified under notifications. Now, Lordship, the single judge held that no, this is a compensation to people who are not affected. Your Lordship, a very interesting position has emerged since then. Subsequent to the Honorable Justice's order, a notification for compensation has been taken out by the state administration, which goes back to our stand. It is now saying that they want to identify people who have rights and thus have to be identified as per the rules of akin to land acquisition. This is not land acquisition, Your Lordship. It is akin to, the process followed is akin to land acquisition. They are as specified in a notice. Lordship, my humble submission is, I'll take you to this thing, is that since they have abandoned the protection or the direction of the Honorable High Court in making these compensations for people who have no rights and are now in the process of having issued notification, and I am told a series of them, the impugned notification in the IA is the first such notification issued in 25, and I am told some more have been issued follow-up. All that is needed to be done is a clarification. This may be disposed of with a clarification that the notification that has been issued has to be preceded by a invitation for objections and claims, as is the procedure. So, Your Lordship, that is all that needs to be done. The order of the High Court may be modified to the extent that this, and I may now take Your Lordship to the notification, which was impugned originally.
Page number.
Page number, Your Lordship, I am taking you to first the original notification, which was, I just get my specs. Since COVID, my reading has become more difficult than it was, but the number has remained. So, Your Lordship, come to page 33 of the writ application. I'm sorry, writ appeal 10. Writ appeal 10, Your Lordship. I'll be following writ appeal 10.
Writ appeal 10.
Writ appeal 10. Now 9 and 10 there are two, but 10 was again 32, which was the original writ.
Writ appeal 10, page number 33.
Page number 33, Your Lordship. Is the impugned. And then then, Your Lordship, before I take you to, you can come to page 111. 111, which is the impugned notification on which that judgment is there. Page 111.
It was impugned in the writ petition.
Pardon?
It was impugned in the writ petition.
That's right, Your Lordship. That's very much correct, Your Lordship. So, Your Lordship, I read paragraph 1, 2, and 3 only. Paragraph 1 says the policy, may I read, Your Lordship? Lordship, page 111.
Yes.
I read para 1, Your Lordship.
Right.
Special ex gratia relief package towards right of way for 132 passing through reserved forest under the comprehensive scheme for strengthening of transmission distribution line. Then, Your Lordship, para 2. For the tribal population as identified in para 3 of this policy, who are not entitled to any benefits including compensation of specific nature, resettlement, rehabilitation, etc. And then, Your Lordship, would be able at the rate of 42.5% and 7.5%. Your Lordship, this is 50% of what is notified, or let us say USF and other areas. Now, Your Lordship, coming to para 3, which is contradicted by para 2. For para 3, Your Lordship, on page 112. For identification of affected individuals where ROW has been duly granted by competent authority, reserved forest, board of officers shall be constituted. Then, Your Lordship, it clearly says akin to board constituted in matters related to land acquisition. The representative of forest department shall necessarily be included. Your Lordship, there is, if I take you to page 115, I'm sorry, 100, just a minute, Your Lordship. FRA. Page 155, Your Lordship. Page 155. I'll just take you to two more pages, Your Lordship. 155. This is a notification of 25th November 2020.
What is it?
Your Lordship, I read.
What is the FRA certificate?
Your Lordship, this is required. This is forest under the law. particularly the Forest Act 2006, such a certificate is required whenever there is an area which is affected by forest where traditional dwellers are there, the 2006 FRA Act, Your Lordship. So under this, a certification is required. This is this certificate. The issue I want to point out to Your Lordship is that this is a certificate where a administrative exercise sitting in a room is being conducted in direct violation to the law. What it says is, para A, the complete identification settlement right of FRA has been carried out in the entire area. Fine. This is not true. The diversion of forest land for fossil government is required under section 3(2) of FRA Act, that the 2006 Act, Your Lordship I referred to, has been completed and the Gram Sabha have been given. In brackets, it says not applicable in this area. So they haven't done anything. The purpose does not involve recognized rights of primitive tribes groups, the agricultural committee, then it says bracket not applicable. So Your Lordship, what done is they have ignored the Forest Rights Act completely, which gives crystallized rights to the residents of the forests. Now, Your Lordship, another, I take you to page 152, just 2 pages behind, Your Lordship. Page 152.
Yes.
Yes, Your Lordship. Para 4, Your Lordship. Again, it refers to earlier notification, Your Lordship, in the reference, in the similar vein. There is no requirement to show notification inviting claims and objections for setting up of transmission lines. This is incorrect, Your Lordship. The law does require. It is correct, Your Lordship. The sentence is very correct. If one were to take only Telegraph Act into account and Electricity Act into account, which precede the FRA Act of 2006. So in the absolute sense, this sentence is correct. But it ignores the FRA Act completely. Whereas this certification, Your Lordship, is effectively in pursuance of the earlier letter which I showed, it's referring to FRA Act. If you see, Your Lordship, the references on top. So, my Lordship, what has happened is, at the time when we came in writ, the status was that there is a notification of August, which I read to you, which para 2 and 3 say that compensation to people who do not have any rights. What we said is we do have rights. Para 3 says identify people who have rights. But these 2 documents which I have just shown have taken recourse to by the department to say that we have got the certificate for a FRA certificate is there and we are going ahead without. So effectively they created 2 classes of people, Your Lordship. One is people who are in USF, that is the other forest areas, and those in reserved forest. Those in other forest areas have been duly given notifications as per law and have been given compensation. We who are in the reserved forest areas, I pointed out, are effectively in 3 categories. One who have LPCs. The petitioners' LPCs were attached. 2, those who have applied for LPCs but are pending. And 3 people who are there present but have not either applied for LPCs or but are physically there. So if right, and they may be holding documents even from before independence times, which will show their property rights. The humble submission, Your Lordship, was that this August 2023 notification is bad in law, it is self-contradictory, covers people who have no rights. Honorable Judge, Your Lordship, in our judgment, upheld this. I'll take Your Lordship the judgment. Your Lordship, paragraph, we can start, Your Lordship, starting from para 2, Your Lordship. Para 2, page 56. Page 56, para 2.
Yes.
Now, para 2, Your Lordship, as you may see in towards the last 4 lines, it quotes from the notification. for the tribal population identified in para 3 of this policy who are not entitled for any benefits, including company of specific nature. And your lordship,
No, from where you are reading?
I am reading para 2, your lordship, page 56. Last 4 lines, 5 lines, your lordship, which are a quotation which I have already read, your lordship. Page 56. This is from the judgment dated 28/1/25.
Yes.
Your lordship, I draw your attention to, excuse me, to the learned judge having quoted the provision of paragraph 3, which I have already read to you.
Paragraph 3 of this policy.
Paragraph 3 of the notification of 31st August 23, your lordship, is duly quoted in the 5th line from the bottom. For the tribal population as identified. Right, your lordship?
Yes, for the tribal population.
In para 3 of this policy is in the policy in that notification. The ex gratia, the amount of half the rates. I just want to point out to you half the rate of what is normally to be paid.
Yes.
Now, in para 3, your lordship, I point out again towards the last line of para 3. It is the case of the learned counsel that the impute notification curtails the rights of petitioner and other forest dwellers as per law, wherein all affected parties must be provided opportunity of hearing, given opportunity to produce the document to establish their rights, which may include the documents of pre-independent era. Lordship, what has happened is the other forest areas were issued a notification for inviting objections and claims, and the reserved forest we were excluded. Now, your lordship, para 5. Before the page 35, your lordship, before para 5 on page 35, there is the end of para 4. I read from the second line from top. Tribals affected by the project who have been having crystallized rights in affected geography as per the schedule tribes and other traditional for the recognition of Forest Rights Act 2006. Lordship, we are people who have rights which are affected. These are crystallized rights. So it's not, we are not people who are not affected by it. But the Honorable Judge, your Lordship, has also noted in para 5 that the notification, para 5, your Lordship, 6th, 7th line, your Lordship, para 5, page 35.
Yes.
This notification provides for full compensation for damages as per Section 67 and 68 of Electricity Act, your Lordship, provides for full compensation of any damages. So, your Lordship, I take you towards the end of the judgment where the Honorable Judge has recorded. Now, your Lordship, page 45. Your Lordship, I am trying to show your Lordship that this order is absent on some issues and perverse in terms of its findings on some. I gently want to take your Lordship through that. But however, the latest notification actually gives go by to this order completely and talks of crystallized rights and identifying the people. So, my Lordship, page para 25. This court finds, this is page 45, your Lordship. Page 45.
Para 25.
I'm sorry, your Lordship. Wait a minute. Wait a minute. I'll tell you the page again.
68.
Page 68, your Lordship.
Yes.
That's right. Page 68. Page 68. Now, Lordship, this petitions are filed for an appropriate rate for setting aside and quashing, okay, for directing the respondent authority to pay land compensation. That's not correct, your Lordship. We are not asking for land compensation. We are asking for cost of duration.
Cost of?
Land duration. Land compensation means land has been acquired. The process to be followed for identifying affected parties is same as land compensation, as Land Acquisition Act. But what is being asked for is not land compensation as per Land Acquisition Act. So this is not a correct finding. Indian Telegraph Act, Scheduled Tribes and Other Forest Dwellers Act is correct. Then to take cognizance of LPC applicants pending with the state administration, invite claims and objections in pursuance of laws related to acquisition of land applicable compensation to rightful. This, your lordship, is a slight, it's misconstrued. What our contention was, your lordship, was you must take cognizance of LPC applications you have. You must take cognizance of LPCs we have submitted, and you must take cognizance of persons who are residing there who have rights but may not have submitted for LPCs. Your lordships yourself in a earlier order have said that these are illiterate, relatively innocent people, and they need to be educated about their rights. I even read that order, your lordship. So what is missing here, your lordship, is that the last part, which is the correct part, is that follow the process of land acquisition to identify the affected party, which starts with the invitation for claims and objections. So our contention was, please invite claims and objections, then issue relevant notifications, verify the claims and objections, crystallize the amounts payable, and then do the needful. We are not saying, give me this money, give me that money. We were also not asking for a stay order, this being a very important project. All we were saying is, kindly identify the people, invite claims, you may keep adjudicating on them later on. Now, your lordship, the honorable judge has held, finally, on para 35, page 73, your lordship. Para 35, page 73. This court also finds that petitioners in the instructed petition have not established that they have, this is incorrect, your lordship, valid LPCs were enclosed with the writ petition. I can show your lordships. And take applications pending with state. Yes, we had requested that they must also be considered, the applications pending. And also people who have not applied but have some kind of right may be allowed to give their claims, and objections may be invited. So the other thing, your lordship,
What the government is doing now?
your lordship, strangely, the government, this court gave an order upholding this notification, which to our mind was a perverse, based on perverse findings. The honorable court, after having this judgment, we have approached in writ appeal, but in the meantime, government has issued a notification. I take your lordships to that notification in the IA 60. IA 60, page 52.
Page number?
Page number 52, your lordship. IA 60, page number 52.
Yes.
Yes. Your lordship, kindly see, this is an order which has got 2-3 drawbacks, and with those rectifications, it can serve us. Number one is, it does not mention reserved forest area, whereas earlier a similar order was passed, and unclassified state forests were covered and compensation given. This order also should have been preceded by an order inviting claims in that area and objections. So all that we want, your lordship, in the present situation, this whole thing can be disposed of with an amendment to the honorable judge's, single judge's order, to the effect that in view of this notification, a petition for objections and claims may be issued, and this may be mentioned that this is for reserved forest, and the matter may pursue as per law applicable for identification of these persons and compensation due to them. Plus, that is one part of it, your lordship. The second part is that they must be treated equal to people having rights in USF, which means they should also get full compensation, not 50%. 50% is for people who are not having any rights. I am talking of people who have crystallized rights under the Forest Act. The First act has been ignored by the earlier notification under against which we came in appeal. This is my humble submission, Your Lordship. This matter can be simply disposed of by Your Lordships with this clarification. Because they themselves have abandoned the protection of the Honorable Judge's order. They are asking for, Your Lordship, if you notice first para, second para, last line. On page 52, Your Lordship, that's a very telling line. Second para, last line on page 52. I read, Your Lordship.
Yes.
Estimated diminution costs of land and properties to the requiring agency for payment of diminution costs to the genuine landowners in the state. So they have gone back to the original genuine landowners, which we were arguing for. And all that needs to be done, Your Lordship. Since reserved forest people are the only ones left, it should be clarified. This is for reserved forest.
This notification does not have anything about forest lands.
Exactly, that's what I'm mentioning, Your Lordship. A similar notification is earlier issued, under which the USF lands have been given compensation. What is left is reserved forest. And the reserved forest lands, this notification has come subsequent to the Honorable Court's order. So, Your Lordship, and they are proceeding on reserved for physically, we can see they are proceeding on reserved forest land, on areas where we are having possessions. But the point is, under the process, due process, they are ignoring our crystallized rights. All we want is, we should a notification as to proceed. And then they do the survey, and they have already might have started doing some survey. We have no problem with that. But we must be given an opportunity to exert, to assert, to claim our rights. That's all we are asking.
Mr.
My lord, as per provisions of law, right to so and so, exactly the prayers what they have made in the writ petition, and now they are turning back. Be that as it may, my lord. Here, my lord, what exactly the writ petitioners are claiming? Writ petitioners are claiming, appellants are claiming that they have rights in the forest land over the reserve forest. Now, if my lord see who are these writ petitioners or writ appellants, my lord will kindly see the address at page 2 of the writ appeal itself.
Page 2.
This is the address, page 2. First petitioner, son of so-and-so, permanent resident of Niti Darlong, POPS, Sejosa, district so-and-so, and presently residing at B sector near Raj Bhavan, POPS, Itanagar, district, Papumpare, so-and-so. The second one also, Sri B sector, district Papumpare, residence address is given. Third one also, residence is of Mobusal, POPS Sejosa, Pakekesang. Why I'm showing, my lord? For the purpose of claiming any right under the Scheduled Tribe and Other Forest Dwellers Recognition of Rights Act 2006, my lord will kindly have that 2006 FRA. No. Not atrocities. What is 2006? उसमें भी है. उसमें भी है.
Scheduled tribes and other traditional forest dwellers. Yes.
Recognition of forest rights, my lord.
Yes.
My lord will come to the definition. Definition, section 2C, who are forest dwelling scheduled tribes. Section 2C, if my lord,
Forest dwelling.
Scheduled tribes. Forest dwelling scheduled tribe means the members or community of the scheduled tribes who primarily reside in and who depend on the forest or forest lands for bona fide livelihood needs and includes scheduled tribe pastoral communities. Now, these are people claiming that they want protection under this FRA 2006. They, on their own showing, they are not residing in the forest or primarily residing in the forest or depending on the reserve forest. How can they claim? Well, this will, the entire writ appeal will need an elaborate hearing. This may be admitted. Let the survey be carried out. If they can make out a case, that will be heard, my lord. This might be fixed for admit and fixed for hearing, my lord. It will require a lengthy hearing, but no interim, nothing at this stage, my lord.
Yes.
Lords, I appear for respondent number 6. The Power Grid Corporation of India Limited, my lord, the executing agency. My lord, if permitted, I'd like to present a few points with regards to the policy. Now, my lords, my learned colleague here has said that the impugned judgment has gone on to make findings and create findings and record them contrary to what they had asked, my lords, if we can come to the prayer of the writ petition, which is the part of the appeal itself. My lords,
Yes.
now, if I have my lords to the prayer, in the original writ petition that they had filed,
Yes.
my lord. My lord, they are praying over there a writ in the nature of certiorari or any other appropriate writs, order, or direction shall not be issued in setting aside and quashing the notice dated 22/6/2020 and 31/8/23 issued by respondent number 3. Writ of mandamus shall not be issued in directing the respondent authorities to pay the land compensation as per the provisions of the following laws. A, my lord, right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Now, my lord, on this very basis, the writ petition is not maintainable for the primary reason being that Schedule 4 to Section 105 of the said Act itself says that we are exempted from any land acquisition proceedings. Now, my lord, in that respect, Century Textile is a landmark judgment, my lord, covering up this issue, which the learned court, single judge, my lord, while deciding this writ petition, has relied upon, because in Century Textile, the apex court has very categorically laid down the law wherein it has said that Power Grid Corporation of India Limited, my lord, by virtue of the Section 164 of the Indian Electricity Act, which grants us the powers of the Telegraph Authority as enshrined in the Indian Telegraph Act under Part 3. And in this instant case, my lord, under Part 3, we will be relying upon Section 10 and Section 16. So, my lord, we do not acquire any land. We only are the users of a particular land. Now, my lord, this is the genesis of the matter, my lord. Now, as being a user of a particular land, my lord, the Telegraph Act required us to pay a certain amount of compensation. Now, that compensation cannot be equated as a land acquisition compensation. My lord, that compensation was in the nature of surface damage, pre-crop compensation, my lord, and nothing else. So, my lord, post this, my lord, page number 114 of the writ appeal.
Yes.
My lord,
Is it notification?
notification. Now, my lord, until 29th August 2019, the only form of compensation which was being paid, as I have pointed out, my lord, was under only under Section 10D of the Indian Telegraph Act, where we were paying surface damage and pre-crop compensation, my lord. Now, my lord, the government in 2015, the union government formulated certain guidelines. And those guidelines were only in the form of a suggestive directive given, which will come into play once every state adopts it. Now, my lord, if I may read this guideline, my lord, it says that the government of Arunachal Pradesh is pleased to adopt and notify the following rates of payment of compensation towards damages in regard to right of way for the transmission lines in accordance with the guidelines of the Ministry of Power, Government of India, dated 3/7/2015, transmission dated 15/10/2015, for maintaining uniformity in compensation payment to the affected landowners. My lord, the word landowner is a very important expression over here in this notification, my lord. Towards compensation shall also be adopted in the state of Arunachal Pradesh. These guidelines of payment methodology of compensation towards damages as stipulated in Section 67 and 68 of the Electricity Act, read with Section 10 and 16 of the Indian Telegraph Act, shall be in addition to the compensation towards normal crop and tree damages. This amount will be payable only for transmission lines supported by tower base 66 kV and above, not for sub-transmission and distribution lines below 66 kV. Now, my lord, the compensation over here was in two aspects, my lord. My lord, when the transmission system is created, my lord, the towers are erected. Now there is below the land below the 4 feet of 4 foot of the tower, my lord. Over there it says that compensation in the nature of 85% of the land value as may be decided by the state government, because my lord, the circle rates of the land are decided by the state government. Now, my lord, second is when the stringing happens between two towers, my lord, that is known as the right of way. So in respect of the area directly below the drawing of the lines, 15% of that compensation amount shall be paid. Now, my lord, this notification was specifically for the landowners. My lords. Now, my lord, what the state government did is, the state government came up, my lord, page number 111. And my lords, we may remember the two values from the previous notification, that is 85%, my lord, and 15%. They'll play an important role in understanding. My lord, may I?
Yes.
My lord, page 111 is that notification which they have challenged. 31st August 2023. In the interest of public service, my lord, the governor of Arunachal Pradesh is pleased to notify the special ex gratia relief package towards right of way for 132 kV transmission lines passing through reserve forest under the comprehensive scheme for strengthening of transmission and distribution system in Arunachal Pradesh. Policy for the purpose of facilitation completion of the statewide project for socio-economic development of the state of Arunachal Pradesh as under. This policy may be called the Special Ex Gratia Relief Package towards right of way for 132 kV transmission lines passing through reserve forest under the comprehensive scheme for strengthening of the transmission and distribution system in Arunachal Pradesh 2023. It shall come into force on the date of the issue of the remain effective until further orders. My lord, now is the important aspect. It says, for the tribal population as identified in para 3 of this policy, who are not entitled for any benefit, my lord. That means these are those forest dwellers, my lord, who are not the owners of the land, but they are drawing a part of their livelihood from the forest, my lord, for which the Forest Act has come into play for them, Forest Dwellers Act. So it is saying for them, what does it say, my lord? Who are not entitled to any benefits, including compensation of specific nature, resettlement or rehabilitation benefits, and ex gratia relief package amount equivalent to half of the rates notified. Why? My lord, the notification which we have visited for 85 and 15%, my lord, would be payable. Now, how it is 50%, my lord, for the 85% which was being paid to the actual landowners for the land which we will be using as a user. Now, these people who are dependent on the forest, and if their livelihood is being affected, the government, out of goodwill, my lord, a social measure, says we will give them 42.5% of the tower base area and 7.5%, that is 50% of 15% for the right of way area. Now, my lord, it will be essential now to go and see the impugned judgment as to what decision the court has come to, my lord. My lord, page 73, my lord.
Yes.
My lord, in fact, my lord, page 72, my lord, para 32, 33, 34, and 35. May I, my lord?
Yes.
My lord. Para 32, page 72.
Yes.
From the reading of the above notification, it is seen that the rates of compensation calculated as stipulated under section 67 and 68 of the Electricity Act 2003, read with section 10 and 16 of the Indian Telegraph Act 1885, can be given to only the affected landowners. Thus, it can be understood that the impugned notification dated 31/8/2023 has addressed those tribal population within the reserve forest area who are considered not entitled to any benefits for not being the landowners, but who have certain rights under section 3 of the Scheduled Tribes and other traditional Forest Dwellers Recognition of Forest Rights Act 2006, my lord, primarily for their livelihood. My lord, the learned single judge goes ahead. The forest, para 33, my lord, the forest rights of forest dwelling scheduled tribes and other traditional forest dwellers on all forest lands under Section 3 of the Act includes 1. Right to hold and live in the forest land under the individual or common occupation, for habitation, or for self-cultivation or livelihood by any member or members of a forest dwelling scheduled tribe or other traditional forest dwellers. 2. Community rights, rights of ownership, access to collect, use, and dispose of minor forest produce which has been traditionally collected within or outside village boundaries. 3. Other community rights of usages or entitlements such as fish and other products of water bodies, grazing, etc. Thus, if these rights have been affected by transmission lines passing through reserve forest, even if they are not entitled under the notification dated 2/9/2019, para 2A of the impugned notification has taken care of them. My lord, the notification which does not cover them is the notification where 85 and 15% was given. Para 2A of the impugned notification is where, my lord, 42.5% and 7.5% was given as a goodwill gesture, has taken care of them, my lord, wherein they are said to be entitled to half the rates, guideline of payment methodology of compensation towards damages as stipulated in Section 67 and 68 of the Electricity Act 2003, read with Section 10 and 16 of the Indian Telegraph Act 1885, though they may not be the landowners. Thereafter, para 3 of the impugned notification refers to the identification of such persons entitled under para 2A of the impugned notification dated 31/8/2023. My lord, the most important paragraphs, para 34 and 35. My lord, may I read para 34?
Yes.
Thus, this court finds that the notification dated 31/8/2023 issued by the government of Arunachal Pradesh could be appropriately termed as a gesture of goodwill to pay special ex gratia relief package towards right of way for 132 kV transmission lines passing through reserve forest, wherein the payment has been computed at the rate of 42.5% of the land value for tower base area and 7.5% of the land value towards diminution value of the land in the width of the right of way corridor due to laying of transmission lines, which would be determined by the deputy commissioner or any other authority so empowered by the state government based on the district rate, circle rate, stamp rate to those persons not entitled under the Electricity Act 2003 and the Indian Telegraph Act 1885, but have certain rights under the Scheduled Tribes and other traditional forest dwellers recognition of Forest Rights Act 2006 within the reserve forest area. For the above reason, this court finds that there are no grounds for setting aside the impugned order dated 31st August 2023, my lord. Now, my lord, the learned additional advocate general has, from the cost title itself, from their petition itself, shown that they do not fit into the definition. So, my lord, the ones who actually are fitting into the definition and deserve, they are being identified by the concerned boards which have been created as per a policy decision taken by the government, my lords, and they are being given the compensation. Now, if the writ appellants herein, my lord, feel that they are the authority, they are also the individuals who should be identified or could be identified for the purpose of this compensatory amount, my lord, then they will have to go and approach those authorities. And I'm sorry, my lord, there is nothing on record to show that they have gone and approached the authorities post passing of the impugned judgment, my lord. And for that purpose, para 35 comes into play, my lord. If I may, my lord, at page 73 itself, it says, this court also finds that the petitioners in the instant writ petitioners have not established that they have valid LPCs within the reserve forest area, which is made clear from the nature of their prayer in the writ petition, wherein the prayer is to take cognizance of LPC applications pending with the state administration. And therefore, their claims for consideration of any compensation cannot be considered at this stage. This court, however, observes that in the interest of justice, the concerned respondent authorities should dispose of any such pending applications expeditiously. Now, my lords, they have not demonstrated that they have gone and approached. And now, my lord, if my lords may visit the Indian Telegraph Act, my lord, section 16.
Section
16, my lord, subsection 4 of section 16. This comes under the part 3, my lord, the powers which we have been bestowed upon us. May I, my lord?
Yes.
Subsection 4 of section 16. If any dispute arises as to the, my lord, we may visit subsection 3 first, my lord, for better understanding. My lord, forgive me, may I please read subsection 3? If any dispute arises concerning the sufficiency of the compensation to be paid under clause section 10 clause D, it shall, on application for the purpose by either of the parties disputing parties to the district judge within whose jurisdiction the property is situated, be determined by him. My lord, this is with regards to the sufficiency of compensation. Now, subsection 4 says, if any dispute arises as to the persons entitled to receive compensation, or as to the proportions in which the persons interested are entitled to share it, in the telegraph authority may pay it into the court of the district judge such amount as he deems sufficient, or where all the disputing parties have in writing admitted the amount tendered to be sufficient, or the amount as has been determined under subsection 3, the amount, and the district judge, after giving notice to the parties on hearing of such of them as desired to be heard, shall determine the persons entitled to receive the compensation, or as the case may be, the proportions in which the persons interested are entitled to share in it. Now, my lord, here is a case where there are disputes of fact. My lord, they have shown that they have put in certain applications before the concerned, before some authority, my lord. Now, my lord, filing an application per se does not give me a right through which I will claim. Now, my lord, if there are disputed questions of fact, my lord, under a writ appeal, least, my lord, even in a writ petition, they cannot claim any relief. What they are trying to claim relief here is through these petitions, my lord, they are trying to say that please identify my rights over there. And they are asking this in the wheel of one submission or the other submission. Sometimes they are saying under the 2013 Land Acquisition Act, give us compensation. Sometimes they are saying this notification is wrong. My lord, it's a policy decision of a state for the social welfare of people. Now, whether they will get 85 and 15% as landowner, or they will get 42.5 and 7.5% as somebody who is affected being a forest dweller, my lord, they will have to establish that. Now, that establishing they cannot do in a writ appeal, my lord, least they attempted in the writ petition. For a disputed question of fact, there are civil court, my lord, where evidence will be recorded, evidence will be led, and then court will appreciate. And keeping this in mind, my lord, the legislature has given the absolute power to a district judge to do so, my lord, because, my lord, that is an evidentiary court. That is the court which will record evidence, appreciate evidence, my lord. So, my lord, at this stage, the transmission line is going on. There is a policy decision which has come for those people, my lord, who did not have any rights. Now, they cannot come and say that we will stay one notification. They cannot come and say that declare this notification as illegal. They will have to make a ground, my lord, as to why are they saying it is illegal. And my lord, see the contradiction they are blowing hot and cold, my lord. First, they say that identify us as those people who are entitled to compensation as being forest dwellers, my lord. And then they are saying that the notification by which those forest dwellers are getting some compensation as a social welfare measure, declare it illegal. And so, my lord, what benefit? How will they reap anything? These are projects of national importance, my lord. And there is a policy decision which the government has brought forth. So, my lord, they have no case over here. They may go around the bushes. They may come with any kind of a submission, my lord. They will not have any case because the law has been defined, codified. They have an issue, my lord, they will go to a district court. Whether it is with
May I,
regard to
Lordship?
the amount of compensation, my lord, or a person who might be entitled for that compensation, my lord. Highly obliged.
Okay, yes.
May I, Your Lordship? Your Lordship. First of all, I would like Your Lordship to just very briefly, there are some markings, Your Lordship, because I was using it. These are the Scheduled Tribes Act, the 2006 Act. My learned friend, Your Lordship, has read out some qualifications for people who are affected in the Act. I would like Your Lordship to go through three. On page 3, Your Lordship, page 3. My learned friend read 3(1)(a), (b), C. But I would like to draw your attention to G. That says rights or conversion of pattas or lease or grants issued by any local authority or any state government on forest lands. Two titles. Would also like to draw your attention to.
But in Arunachal Pradesh, there is no system of pattas.
Your Lordship, this is just to show there is a system here of traditional grants which have been made in the British times, which some of the parties affected have. I am aware of it. So that's not a patta system, but it's an analogous system. There is some land right is transferred, but it is not recorded in the revenue record because these are not revenue villages. Now, Your Lordship, coming to the section 4(3) on page 5. Section 4(3) on page 5. Section 4(3) on page 5. The recognition and vesting of forest rights in this act to the forest dwelling scheduled other traditional dwellers in relation to any state or union in respect to forest land habitat shall subject to condition that such scheduled tribes or other traditional dwellers had occupied lands before 13th day of 2005. The qualifying criteria is there having occupied the land before 2005. Somebody may be having an address in the city nowadays, Your Lordship, because the family may be in the village. They have rights in the village. Aadhaar card I have in one city. My voting card is in a different city, Your Lordship. A right conferred on para 4, Your Lordship, under section 4(4). A right conferred by section 1 shall be heritable, but not alienable or transferable. This is akin to a land right, Your Lordship. This is akin to, and then the next para says, the same in the both suspect married persons live single in case a household headed by a single person is absent of directors, the heritable right shall pass on to the next of kin. Your Lordship, even in rest of India, where we have lands for scheduled castes, they are having similar clauses. They are heritable but not alienable, but they are belonging. Your Lordship, I bring to your attention another aspect. I agree 90% plus with the fact presented by a learned colleague from Power Grid. But what he fails to understand, Your Lordship, is that in the forest, there are crystallized land rights, as per the clauses I have just read to you. And we, the petitioners, are covered by those crystallized land rights. The unfortunate part, Your Lordship, as I mentioned earlier, is that these crystallized land rights are not often documented with the state or even with the owner because of historical reasons. And Your Lordship, we were not in writ and we are not in appeal now to ask for a specific compensation. We are not on facts. We are on the law. The law is 85 rupees and 15 rupees compensation should be given in case of duration of land by transmission line above 66 kilovolt. We are saying the same law should be applicable in case somebody has a land right in the forest, reserved forest area. And we are claiming we are having land rights in the reserved forest areas which remain unidentified for the reason of notice not having been issued, calling for our rights and objections, claims and objections.
Okay, Mr. Kaisa, we will need a hearing here.
Pardon, Your Lordship.
We will have to have a hearing here.
Yes, Your Lordship.
So we will go for a hearing.
Okay, Your Lordship. Much obliged.
Who
Give
is
me a
appearing?
fixed date, Your Lordship.
Mr. Rotan is appearing for whom?
Except for 6, 1 to 5 and 7.
Mr. Khera is for 6.
My lord, I'm
Yes.
for 6. Power Grid Corporation of India Limited in both the appeals, my lord, 9 and 10.
And who is for the 5? Commissioner Tribal Affairs. You can also.
Well, that also, except for 6, all.
And for
1 to
7,
3, 4, 5 and 7.
Mhm.
1, 2, 3, 4, 5 and 7.
Or Mr. A. Kashyap, appearing for the petitioners.
Nine.
Or Mr. Andrew from the Additional Advocate General for the appearing for the respondents 1, 2, 3, 4, 5 and 7.
Yes.
Or Mr. M. Khera, appearing for the respondent number 2.
6, my lord.
You are respondent number 6.
6, my lord.
M. Khera, appearing for the Learned Council. Mr. M. Khera, appearing for the respondent number 6.
My lord.
The appeal is admitted for hearing. This on when we want it.
Your lordship, as early a date as possible, a Monday if preferable, your lordship, that saves me a Sunday for coming here.
Monday not possible. It will go to the month of April. You can suggest one date in the month of April.
Month of April.
My lord, 9th of April.
Monday. 9th of April seems to be good, your lordship. 9th of April is good for,
Okay, then list on 9th of April for hearing.
as a fixed date, your lord.
Yeah, fix that. In both the appeals, same order.
Yeah.
Both the appeals, item number 3 and 4. Same.
Much obliged, your lordship.
Always.
Lordship, if we would, if we need to file any affidavit to bring certain aspects on record, the window may be kept open for us, my lord. We'll
Okay,
file it before the 9th.
The respondent number 6 has the liberty to file affidavit before that date.
My lord. Highly obliged, my lord.
May I please, my lord?
Yeah.
My lord, in this case, I'm praying for the consideration of the IA, my lord. Since the issue is very limited in this case. My lord, I have been convicted under section 376 and 302. My lord, solely on the basis of one DNA report, my lord. Without there being any corroborative evidence.
So where is the I?
IA, my lord. If my lord may take up the main appeal, I have the judgment and everything there.
What is this I for?
IA for suspension of sentence and granting of bail, my lord.
Rape and murder.
Yes, my lord. But in this case, my lord, the accused has been convicted solely on the basis of one DNA report. No other corroborative evidence, my lord, which is not permissible under the law.
No eyewitnesses.
Nothing, my lord. Zero witness. I can show from the record, man. Only one. In fact, there are two DNA report. One is negative and one DNA report which has been taken after 5 months. That came to be positive. And relying on that DNA report, I have been convicted,
So show it from the judgment.
my lord. Page number 368 of the main appeal, my lord. Para 105 and 106, my lord.
368.
368.
Yes.
If I may read paragraph 105. It is found from the evidence available on record that dead body of the deceased victim girl was recovered in almost naked condition with multiple injury and her wearing apparels were torn and put off. The inquest report paper exhibit 5 and PME report paper exhibit 2 of the dead body of deceased victim girl revealed that she was subjected to sexual assault at the time of her murder. PW 19, 20 and 21, who are doctors conducting PME of disease, also affirmed that the disease was wrapped during the time of her murder. Vaginal swab of the disease and dried white patches from inner thigh of the disease were collected and the same were handed over to the IA for FSL examination. CW5 FSL expert has affirmed that during the examination of the urethral swab and vaginal swab of the diseased human was found, spermatozoa was found. On further examination, CW5 FSL expert has found that the DNA of vaginal swab and urethral swab of the deceased victim girl match with DNA of accused Pasang Tashi, who is the present appellant. In view of the above, it is found from the material evidence available on record loudly revealed that accused Pasang Tashi Sanu is involved in rape and murder of deceased victim girl. Now, prosecution alleged that all the accused person in furtherance of their common intention have raped and murdered, sorry, my lord, common intention have committed rape and murder of the deceased victim. Evidence revealed that
How many people were convicted here?
no, my lord, altogether there were 8 accused, my lord.
8 accused.
8 accused. I am the only person who is convicted. And there's not even a single prosecution witness or any other co-accused who has given any inculpatory statement against me.
How she died? What is the cause of her death?
My lord, which is not known, my lord, still.
Still not known.
Not known, my lord. As per the allegation, it says that, my lord, she has been raped and murdered. But there's no allegation against me. I can take, my lord, take through the depositions, my lord. There's not even a single witness against me.
Where are the depositions?
Well, starting from page number 157.
One?
157.
87.
157.
157.
My lord, the type copy is at 159.
159.
59.
PW1.
My lord. Is the father, my lord, if I may read, my lord. I have come to this in connection with the case related to my deceased daughter. I left my workplace at the evening at 5 p.m. The date of the said incident was 28, but month and year I do not remember. After reaching home, I did not find my daughter. I was looking after the sick younger daughter, and my wife, along with Lama and one girl, went out looking for the missing daughter. Later on, some more people joined them. They called the friend of the missing daughter to know her whereabouts, but in vain. They searched all the main roads and villages, but could not trace out the said missing daughter. Midnight, the people who were searching made a call to me, for which I told them to stop searching at night so that they start searching early in the morning. Early in the morning, I went out searching for my daughter, and while doing so, I saw a mark, which seems to be a mark from where the person had been dragged. So I further looked down and I saw the tiffin box of my missing daughter. And on further looking down, I saw my daughter lying naked, except a banyan and an underwear open till knee. I found except in a gompa nearby, where I went and called the Lama to help me. I called my wife from there with the help of the mobile of the said Lama and told her to come soon with the blanket, as the said missing daughter is found and lying dead in naked position. We all waited till the arrival of the police. Since it was a police case, we did not want to go down and tamper the evidence. Later on, the police arrived and seized some materials, evidence like empty bottles of rum and cigarette packets. Paper exhibit 1 is the complaint, which I lost, and so and so. Well, this is the cross has been declined. Now, my lord, second, my lord, page number 161. The type copy is in page number 162.
Yes.
I have come to this court to give my statement in connection with Ms. Dawa Drama since disease. I gave my statement to the police officer in connection with this case. I know the 3 of the accused persons standing on the dock out of this 8 accused persons. Altogether, there were 8 accused persons. They are namely Raju Lama, Papu, and Tanzin. These accused persons whom I know are originally from Nepal, but at present they are residing at Krimu village. On 28/8/2012, I received a missing case. I'm a village authority. In fact, my house is located away from the village, but I joined the search operation. The name of the missing girl is Dawa Drema. The girl was found missing at Hau area. I, along with 4 youths, reached the house of the father of the victim as soon as I got the message. I reached at around 9 at night. It was raining, so we thought the missing girl might have down from the hills, but we went to a spot where some people met the missing girl on the way. These people met this missing girl at around, see, my lord, these people met this missing girl at around 4:30 p.m. in that spot, my lord. Not me, my lord. Other 3 accused. We went searching from that spot. We saw Raju Lama in his car, by then just 60 meters away from the said spot. I wanted him to stop his car as he was coming from the opposite direction. He stopped his car little away from the place where I was standing. I told Raju Lama about the incident of the missing girl, on which he replied that he also know the missing girl. Hence, he said that he will inform us in case she is found on the way towards India Gate, as he was going that side looking for 2 friends who were on bikes. After 30-40 minutes, said Raju Lama came back to this Alto from India Gate. I wanted to know from the driver of this Alto as to why he is moving to and fro at this night time. He did not stop his car where I wanted him. Rather, he went distance away from the place where I was standing. He had to stop his Alto because there was a van parked in the middle of the road. I went nearer to him, for which he opened his car window and told me,
Yes.
May I please, Your Lordship? Your Lordship, item number 20. I'm for the applicant, Your Lordship. Here, Your
20?
Lordship. Yes, Your Lordship.
2020. The accused has been arrested, Your Lordship.
Yeah.
Now it's becoming infractuous.
Rested.
Yes,
Yes,
Your
Your
Lordship.
Lordship. There are no interim was there, Your Lordship.
And, the learned counsel, Mr.
E. Menjo, Your Lordship.
as well as Mr. T. Attended in learned tradition upon the prosecutor submits that petitioner has already been arrested by police and therefore this application has become infractious. After hearing both sides, the present application stands closed and disposed of.
Deeply obliged.
Wait to mention item number 35, hearing matter, my lord. On joint prayer, my lord, may this matter be taken up in the second week of May.
Second week of
Hearing matter. Joint prayer,
35.
35. CRP 23 of 23.
The learned counsel, Mr.
BK
BK Singh, appearing for the petitioner.
Is there? Respondent.
And
Okay.
you are for the respondent,
Yes, Lordship, I'm for the respondent.
as well as Mr. What is your name?
Your name?
Tito.
Uh,
Tito.
Appearing for a respondent, jointly praised for an adjournment. The hearing is adjourned according to when do you want it?
Second week of May, my lord.
Second week of May. Release this matter in the second week of May 2025 for hearing.
Hearing. Obliged. Yeah, please, my lord, I would like to mention one unlisted writ petition for withdrawal, ma'am, for listing to them. Ma'am. It's only for withdrawal.
Oh, withdrawal.
Withdrawal.
Withdrawal of what?
Writ petition, ma'am.
May I please, Lordship? Lordship, I beg to mention item number 34, Lordship. Lordship, this matter may be listed after 3 weeks, Lordship.
You appearing for Mr. Parme,
No, Lordship, I am for the respondent,
or
Lordship,
you are for the respondent?
on behalf of B. Jamal, Lordship.
Visa move.
And Lordship, in the meantime, I have taken consent from the petitioner, Lordship.
Should be taken consent.
Lordship, yes.
What is your name?
K. Tabang, Lordship.
The learned counsel, Mr. Kitawa, appearing on behalf of Mr. V. Jammu. The learned counsel for the respondent prays for an adjournment and also submits that he has already informed the appellant. The hearing is adjourned accordingly. When do you want it?
3 weeks, Lordship.
List after 3 weeks for hearing.
They believe us. May I, my lord?
Yes.
I beg to mention item number 11 on behalf of Abhinav Prakash for the petitioner.
Item number 11.
Yes. My lord, this leading counsel is from Delhi, so kindly matter may be fixed for
Item number 11.
11. It's an admission.
You are for the respondent or
The petitioner,
for the petitioner?
yes, on behalf of Abhinav Prakash.
But his name is not here.
Yes, my lord. His name is not reflected in cost list, but it is in Bakalat Nama.
What is your name?
P. Harming.
Mr. P. Appearing for the petitioner. Submits to the learned conducting counsel, Mr. What is his name?
Abhinav Prakash
Avinav Prakash.
is from Delhi.
He is not available today. He was
Yes.
granted adjournment has been paid for. Have you informed the other side?
Yes, I have taken consent.
The learned counsel also submits that he has already informed the other side. According to the matter is adjourned today. When do you want it?
28th April.
List on 28 April. For admission hearing. The name of the learned counsel, Mr. Avinav Prakash.
Yes.
Prakash or Pratap?
Prakash.
Prakash.
Yes.
Shall be shown in the call list as the counsel representing the petitioner.
Maso.
May I please, your lordship? Lordship, I beg to mention listing of an writ petition, your lordship, for only for withdrawal. Yes, your lordship. Your lordship,
Withdrawal of what?
of the petition, your lordship, writ petition.
Read petition.
Yes, your lordship.
You want to withdraw it?
Yes, your lordship.
Okay, today.
Today, if this matter, much obliged.
Yes,
My pleasure, Lordship.
yes.
My Lord, I am the petitioner in this revision petition, my Lord. The facts of the case is this: the petitioner is the owner of 16,000 square meter of land, and his land was illegally occupied by the respondent. And he referred the matter to the village Kabang. And Kabang, he prayed for time because of his death of his son. But the Kabang passed an order against the petitioner, holding that he is not the other side is not illegally occupying the land. Thereafter, my lord, the petitioner preferred an appeal before the deputy commissioner, and deputy commissioner directed to prefer an appeal before the civil court. Thereafter, he filed an appeal before the civil judge senior division, which was numbered as civil appeal Kaba 28 of 24, along with a prayer for stay, which was registered as IA 88 of 2024. And the learned civil judge, by the order dated 26/11/2024, passed an order for maintenance of status quo. Against that order of status quo, the respondent preferred an appeal before the district judge. And district judge stayed the order of the civil judge on the ground that there was no prayer for status quo in the appeal, because we made a prayer for stay of the improved order. Where it is not necessary to maintain status quo. It is the discretion of the court to grant the status quo order when there is a petition for stay. Therefore, I have come against that order. That is order passed on 11/2/2025, which
Mr. Sharma, where is the
108.
108?
Yes, madam.
You prayed for stay of the order.
I prayed for stay of the order, and the learned civil judge granted status quo.
No.
Your lordship can see when the improved order was passed by the civil judge senior division, the advocate for the respondent was present, and he did not oppose the prayer for status quo, and he only prayed before the court and the notice may be issued, and that order is reflected in the order, my lord. Therefore, the passing of the status quo order, it cannot be said to be illegal or unconstitutional. Therefore, my lord, I pray that this revision petition may be admitted, and the order passed by the district judge on 11/2/2025 may be stayed. Moreover, your lordship will see, if the status quo order is passed, neither the petitioner nor the respondent will be affected. If they preferred an appeal against the order of status quo, it seems that there is something wrong in with the respondent's matter.
Anybody for a respondent?
My lord, I am for the caveator, my lord. I have filed the Wakalatnama and I am entering appearance. My lord, subject to what my learned senior friend is saying, my lord. My lord, what has happened, my lord, if I may state the facts, my lord. A Kabang decision was passed, my lord. That Kabang decision was challenged, my lord, under Arunachal Pradesh Civil Code Act 2021 under Section 15. And that Kabang decision, my lord, was challenged, and that was by an order dated by the Civil Judge Senior Division, the status quo order was passed. However, my lord, we were apprehending that, my lord, that Kabang decision will be challenged. We had filed an application for caveat, my lord. And without, my lord, serving copies to the caveator, my lord, that status quo order was passed. Although, my lord, the caveat was in place, my lord, and my lord, the learned trial court has observed also that the caveator is present and he should be served copies after the passing of the order, my lord. And against this order, my lord, we have challenged before the learned district judge, my lord, under 15(2), my lord. And 15(2), my lord, the learned the impugn order, my lord, will kindly come to, it is reflected, my lord. My lord, at page 108 it starts. My lord, it kindly come to page 109, my lord. Page 109, and my lord will kindly come to paragraph number 3, my lord. May I read, my lord? Page 109, paragraph 3, my lord.
Yes.
Lord, Mr. So-and-so has submitted that the impugn order has been passed in total violation of the mandate of section 148A CPC. When caveat has already been filed, the appellant should have been heard before passing an order. In the present case, the status quo order was passed even before the appellant was served with the appeal petition. Therefore, he had no opportunity to place appropriate reply to satisfy the court. Also, in the appeal, there is no specific pleading or status quo order. It is the settled principle of law that when no prayer for a particular relief is sought for and no pleading is there to support such relief, and the opposite party has no opportunity to resist such relief, the court cannot grant any relief. Further, in the IA filed by the respondent, there is no specific prayer for status quo. Learned counsel has further submitted the appellant is carrying on activities, agricultural activities which does not substantially alter the nature and condition of the land. There are standing vegetables and other agricultural plants which are on the verge of decay and waste due to the impugn order. Also, the appellant has invested huge amount of money and labor carrying out the agricultural activity in the land. If he is restrained from entering the land, the aforesaid agricultural products will rot in times to come, which cannot be compensated in any manner. For the aforesaid reason, the appellant has asked for interference. I have gone through the order dated 26/11/2024. The order itself reveals that caveat was already in place and status quo order was passed before the memo of appeal and connected IA was served to the appellant. And there is no specific prayer for status quo either in main appeal or in the IA. Further, no order has been passed in IA. Two things emerge from the aforesaid paragraph. Firstly, there is a violation of natural justice as the learned court has not afforded a reasonable opportunity of hearing, which has the potential of resulting in miscarriage of justice. Secondly, the learned court has granted the relief to the appellant without there being any specific prayer and pleading to support such prayer. Further, next paragraph. Further, it appears that the appellant is only carrying out agricultural activity, and if that be so, there is a possibility of irreparable loss which cannot be compensated by monetary damages, which has no adverse bearing on the respondent. In view of the above, the order dated so-and-so passed by the learned civil judge senior division PhD is suspended until further order. Issue notice, appellant shall take it, and the case is fixed on Melot 28/3/2025. And instead of appearing before the learned Melot appellate court, the petitioner has filed this application under 227 before this honorable court. And my lord, if I may take, my lord, to the civil judge senior division's order, my lord, against which we went in appeal. My lord, may kindly come to page 18, my lord. I'll kindly come to page 18. It is a short order, my lord. I will take my lord to kindly come down to 5, my lord, page number 5.
5.
Yes, paragraph number 5, my lord. Page 18, my lord, paragraph number 5. Page 18, paragraph 5.
Yes.
Heard, if this honorable court got it. Heard as the counsel for the respondent so-and-so, who is also the caveat, is present today. Copies of the appeal memo along with ISO to be served immediately. Learned counsel for the appellant submits that the appellant has started clearing in the land. In the interest of justice, prayer is made for suspending the operation of the impugn so-and-so, a decision for which IA has been filed. Heard as the respondent caveat has appeared through the counsel that there is no further need to serve notice regarding the appeal. In the meantime, both parties are directed to maintain status quo with respect to the land. No party shall carry out any further construction or enter into suit land till the next date. And my lord, if my lord sees, my lord, there, my lord, petition, my lord, and their IA, my lord, will kindly come to the IA filed by them, page 71, it starts, my lord. Page 71, my lord, IA filed by them. At page 71, it starts, my lord. My lord may kindly come to the prayer portion at page 86, my lord. Prayer portion at page 86.
Yes.
Has my lord gone? My lord, kindly see the prayer. In the premises mentioned herein, it is prayed that your honor may be pleased to suspend the operation of Keba judgment so and so passed by the CG village authority till the disposal of connected appeal, pass such order as deemed fit and proper and in the circumstances of the case. My lord, there was no prayer for status quo. And caveat was also in place without serving us copy. My lord, the learned trial court has passed an order against us, and it is against that order, my lord, we have challenged before the learned district judge under 15.2 and 15.2, my lord, the learned district judge has a jurisdiction to decide an issue arising out of the civil judge senior division. If my lord takes this Arunachal Pradesh Civil Court Act, my lord, because they have raised an issue of jurisdiction, my lord, that is why I am taking this honorable court. My lord, may kindly come to section 15, appeals. Has my lord got it?
Yes.
My lord, can you see 15, my lord, appeals, etc. Number 1, my lord, appeals from the decree or order passed by court of district judge or the court of an additional district judge in original student proceeding of a civil nature when such appeals are allowed by the law lie to the High Court. Number 2, appeals from the decrees and orders passed by a court of civil judge senior division in original suit and proceeding of civil nature when such appeals are allowed by law lie to the court of district and session judge of that district or the court of additional district judge where such court exists or where the High Court as the case may be. So under 15.2, my lord, who has filed the appeal against an order, that was an interim order, my lord. That was an interim order. The appeal is yet to be decided and it is fixed on 28.3. My lord, having said so, my lord is aware, my lord, under 227, my lord, 227 jurisdiction cannot be, my lord, entertained at the drop of the head, my lord. And this has been laid down in Salini Shetty judgment, my lord is aware of that. My lord, they have to show a patent perversity, my lord. They have to show a patent perversity that the learned trial appellate court has committed some patent error, for which this honorable court needs to intervene under 227. My lord, there is no illegality. 15.2, under 15.2, the learned district judge has the power to entertain the appeal, and it has entertained that appeal. And the appeal was challenged on the ground that our caveat was in place, we were not served copies. Thereafter also, the learned civil judge senior division has passed the status quo order without giving us an opportunity of hearing. And when there was no relief prayed for, I have not prayed any relief, then also a relief was granted. It is on these limited grounds, the appeal was filed, my lord, under 15.2. And I, my lord, with all respect to my learned senior, my lord, this petition, my lord, under 227, my lord, does not, my lord, this order, my lord, does not call for any interference under 227, my lord. Because on 28.3, they can very well agitate before the learned district judge, learned honorable district and session judge Pasighat, my lord, regarding the issue. And they have filed this application, my lord. And the case is fixed on 28.3, my lord. So my respectful submission will be that, my lord, this petition may be dismissed, my lord. We may agitate all these issues before the learned district judge, where the issue is pending before the learned, because the issue is very limited, my lord. The appeal cannot be decided by the learned district judge, my lord, the appellate court. This will be decided by the learned civil judge. We had against an interim order, again, we have filed an appeal.
The court will examine this matter at length. So for the time being, the impugned order will be stayed.
My lord, staying.
Heard the learned senior counsel, Mr. Isha Sharma, appearing for the petition. Heard Mr.
NVP Sinha.
NVP Sinha.
Sinha.
Appearing for a respondent. Did you file caveat?
Yes, my lord.
Appearing for a respondent stroke caveator. This revision petition is admitted for hearing. When do you want it? For hearing, Mr. Sharma?
Any date, my lord, because after Bihu break, my lord.
Release this matter after Bihu vacation for hearing. Till then, the impugned order dated 11/02/2025 passed by the district judge Pasighat, East Siam District in PSG Civil Appeal number 03 of 2025 shall remain stayed. The caveat you write, heard the learned counsel, Mr. NVP Sinha. NVP Sinha.
Yes, sir.
Appearing for the caveat stands discharged.
Yes, sir.
Highly obliged, my lord.
May I, Your Lordship? Lordship, we have filed this application under 227, praying for assailing the legality, validity, and propriety of the impugned judgment letter dated 2024, signed on 28/12/2024, issued by the respondent number 5. Along with that, the
Where is
so-called
the,
notice-
where is the judgment?
Your Lordship, it's in page number 23, not the judgment, Your Lordship. This is an order.
Page number 23.
23, Your Lordship. With that, Your Lordship will see,
Order passed by?
or this is actually an order that was passed by respondent number 5, Your Lordship.
Inter-village
Inter-village Territorial
Territorial-
Customary Code of Yangtze Circle.
Territorial Customary Court of
Yangtze Circle.
Yangtze Circle.
Yes, Your Lordship. So that person, in that capacity, he has passed this order whereby he has transferred the case from, there is a dispute, Your Lordship, with regard to land. So what he did, this person who has issued this order is a respondent number 5 in this, before this honorable court. Now, when this matter is actually pending before the Inter-village Territorial Customary Court of Yangtze Circle, where he's not even the Gaon Bura. So now what he did was, he had transferred this order from the village level to a purported stating all Arunachal Pradesh apex customary court, Your Lordship. Whereas apex customary court of Arunachal Pradesh does not even exist. So that being the issue, first thing is he had transferred the case, which he is not authorized. Second, the case which has been authorized to be taken up before the apex court of Arunachal Pradesh, that does not even exist, Your Honor.
Apex Customary Court of Arunachal Pradesh does not exist.
No, Your Lordship, no, it does not exist. So therefore, there is two contention that is before this honorable court. First is that there is the order which is 22/12/2024 itself is not correct. Second, there is no all Arunachal Pradesh apex customary court, Your Lordship, which is clearly seen in by the Arunachal Pradesh Civil Code 2024, as well as in the Regulation Act, Your Lordship, in the Assam Regulation Act.
Today I will issue notice.
Yes, Lord. Lordship, we are praying for the stay, Your Lordship, with regard to the order that is passed. So
Which
I'm
stay?
praying at this
RMS,
Taku, Your Lordship.
Tapi,
Taku.
Taku.
Yes, Your Lordship.
Appearing for the petitioners. Issue notice to the respondents. The petitioner shall take steps for submission notice upon the respondents by registered postage agent. Least up to 4 weeks. Till retirement date. The impugned order dated 22/12/2024.
Lordship 2/3/2025 also.
22/12/2024.
And Your Lordship 2/3/2025, where a notice was issued by the respondent number 6 to the petitioners, Your Lordship. So we are actually praying for this staying of this order because they are directed to appear before the apex.
Page number?
If Your Lordship would see, it's in page number 24 to 26, Your Lordship. That is the so-called notice.
You want stay of that notice?
Yes, Your Lordship.
Till returnable date. The notice dated 02/03/2025.
Yes, Your Lordship.
Issued by the
Respondent number 6.
respondent number 6. To the present petitioners. Shall remain stayed.
Yes. Your Lordship, if that can be added, the further proceeding also that has been stayed along with the notice, Your Lordship.
It is also directed. The further proceedings of, what is the case number?
There is no case, Your Lordship, only the order dated 2/3/2025.
Further proceedings relating to the said notice dated 02/03/2025.
Yes, Your Lordship.
shall also remain stayed until further order.
You'll be obliged.
Number 3.
May please allow.
Yes.
There's one more revision arising out of a Kebang proceeding, my lord. Here, my lord, I'm aggrieved by the order dated 8/1/2025. Your lordship,
Order.
my lord, page 218.
2-1,
218.
2-1-8.
8.
Yes.
My lord will come to the page 222, the findings of the court, paragraph 19 onwards. In the light of the contention raised by both the parties at the outset, it appears pertinent to mention that for condoning the delay under Section 5 of the Limitation Act, the applicant has to show that he had sufficient cause for not filing the appeal within the prescribed period of limitation that would warrant the condonation of delay. The appellant so-and-so herein is aggrieved against 3 Kebang decisions. My lord, kindly note this sentence, my lord. Aggrieved by 3 Kebang decisions: 21/3/2015, 27/4/2015, and 7/10/2018. And the period of limitation has been calculated from the Kebang decision 7/10/2018. Giving the reason that the earlier 2 Kebang decisions were merged with the final Kebang decision, I have perused all 3 Kebang decisions annexed in the so-and-so, which shows in the first Kebang decision dated so-and-so held between the appellant and the respondent, wherein the Ayang Village Authority decided in favor of the respondent so-and-so. The dispute is for the land known as Goklung Arapik Are. The second Kebang decision titled Bango Kabang decision dated so-and-so was held between the same parties for the same disputed land. The perusal of the decision shows that this second Bango Kabang was not satisfied with the Ayang Kabang decision. The second Kabang once again decided in favor of the respondent. The third Kebang dated 7/10/2018, Bogong Bokang Kebang, which is annexed as Annexure 7 of the Memo of Appeal, which was once again held in the third Kebang. The earlier 2 decisions so were upheld. Now, pausing here for a moment, my lord. The other 2 decisions, my lord, though the court has referred it as a new Kebang, it was an appeal, continuation of the earlier proceeding, which was subsequently been upheld on 7/10/2018. Now, the court arrived at a finding at page 224, 23, paragraph 23.
Yes.
In the case in hand, the repeated Kebangs were held between the same parties for the same disputed land by forums of village authorities after the village first Leban Kebang of 2015. But the subsequent Kebang decision passed by Bango and Bokong Kabang could not have taken place in view of the fact that Assam Frontier Regulation Administration of Justice 1945 does not recognize any inter-territorial customary code or apex customary code. Both the subsequent Bango Kebang decision and the Bogam Kabang decision so-and-so were passed by the village authority who were not vested with any authority at that point. And as such, even consent of the parties cannot confer jurisdiction upon a forum with no legal sanctity. The appellant herein has not filed any appeal against the Kebang decision dated 2015, which is also acknowledged by the DC by order dated so-and-so while disposing the execution case number so-and-so. Now, my lord, this is absolutely incorrect because, my lord, the Assam Frontier Regulation was amended in 2023. Let me just place that amendment. And the effect of that amendment was given from 28th of February 1987. Now, it is correct that initially the Inter-Territorial Council and Apex Council were not recognized as a village authority. Now, your lordship will kindly see first, 1, the effect. It shall be deemed to have come into force with effect from 28th February 1987. So this amendment has been given a retrospective effect from 20th of February 1987. Now, my lord will kindly find 3 Roman 4. After clause E, the following clauses shall be added, namely, village authority means members of traditional council or inter-village territorial council or apex council by whatever name called, including Gaubura, head Gaubura, Gauburi, and traditional village head. Now, my lord will kindly turn to the next page. substitution of section 24. In principal regulation in section 24, for existing entries, the following shall be substituted. Any party aggrieved by a decision of the village authority may appeal within 30 days before the inter-village territorial customary court or apex customary court by whatever name called, who on such receipt of this appeal shall dispose the case, provided that the proceeding in the village authority or inter-village territorial customary court or apex customary court, as the case may be, shall be recorded in writing in the respective vernacular or English, as the case may be, provided further that if agreed to by the parties, if aggrieved by the party desires to appeal, as the case may be, an appeal arising out of the coast decision of the village authority or inter-village territorial customary court or apex customary court, as the case may be, shall lie before the court of judicial magistrate first class, the court of chief judicial magistrate in the court of district judge, or in the court of district and session judge, as the case may be, as per their territorial and pecuniary jurisdiction, who shall not set aside an appeal so filed merely on technical ground or procedural lapses in the interest of justice, dispose the same as may be deemed appropriate, or proceed with the case de novo. So, the subsequent Kabang decision were not an original Kabang decision in my respectful submission. This is a continuation, and therefore the computation of limitation which has been done by the court below, that's in my respectful submission is incorrect. Because this is a body which has been recognized by the law. The
period should have been calculated from the first one.
Yes, it is calculated from the first. The court arrived at a conclusion that there was no appeal against the 2015, whereas these were the subsequent appeals before the territorial council. And against that territorial council's order, I preferred the appeal where there is a delay. Now, it's a very settled law. In fact, Supreme Court in the recent judgment also has said that in a case of limitation, court will have to see whether the explanations given are correct or not. Instead, the court will not go into the merits of the case.
Is there any caveat or no?
There's no caveat.
My lord.
You are appealing.
Yes, my lord, I am appearing for respondent.
I will have to hear you also.
My lord, I am yet to receive a copy, my lord. In fact, my lord, so far I remember that, my lord, there was a,
Till it able that I will stay this order.
my lord.
Plus this order, plus take this order will serve nothing, because this is a dismissal of my
Or this
appeal.
will stay
So
order.
I am praying for stay of the Kabang decisions, my lord, because they have preferred an execution, but the execution till date has not taken place. The position is still with the petitioner.
Heard Mr.
My lord, I am objecting against that, my lord, staying of the Kabang decision, because my lord, the case before the lordship is only pertaining to the, my lord, IA. In the IA, wherein, my lord, 1,983 days was not condoned. So the issue before this honorable court is only to ascertain that whether not condoned of 1,983 days was, my lord, as per the law or not. That is to be a certain part. So, my lord, this so far the case is concerned, merit of the appeal, my lord, cannot go at this stage, my lord. So, my lord, I have no objection. Let the notice be issued and copy to be sharp to me, my lord.
Heard Mr. Your Kaushik.
Well,
What Kaushik I forgot?
B. Kaushik, my lord.
B. Kaushik. Appearing for a petition. Heard Mr. C. Modi. The learning council appearing for a respondent, sole respondent. No formal notice is required to be sent to the respondent, as because Mr. Modi has accepted notice. Extra copy of the petition shall be provided to him. List again after 4 weeks. Till returnable date. The KEBA decisions. Dated 21/03/2015. It is the first one.
My lord, first one. And append
Comma,
later.
27/04/2015 and 07/10/2018 shall remain stay.
Grateful, my lord.
Yes.
My lord,
Is it a joint petition?
this is the joint application filed by the petitioner. Petitioner number 1, SA, my lord, informant, and the petitioner number 2, as accused person. In fact, in connection with the Kimin PS case number 08 under section 332, 353, and there was a counter complaint by the petitioner number 2 also. So I'll take the lordship to the page number 12. Is the FIR, my lord?
Yes, yes. Is a policeman?
Yes, both are policemen, my lord. Both are, yes, both are in the same department. So, my lord, we have amicably resolved the matter and we are here.
One was in uniform and the other was not in uniform.
My lord, so for the allegation, my lord.
Hmm.
So, my lord, in page number 12, with due respect and humble submission, I would like to inform you that today on the 5/5/2024 at around 8:30 hours, Shri Rakesh Kumar Jha of the Kimen Police Station has assaulted me without any provocation while I was discharging my duty in the uniform at the check gate.
What is this page number 13? Complaint made by Rakesh Kumar Jha?
My lord?
ASI.
Page
13?
Yes, this is the counter complaint filed by the petitioner number 2. So both the case has been registered. And now in the, this has been registered under section 341 and 323 of the IPC, my lord.
Which one? This one?
Second one, my lord.
Second one?
Yes.
Second one is still going on.
Both the case is still going on, my lord. This, and my lord, I have been informed that so far the first one is concerned, the charge sheet has already filed. But the conclusion is yet to be taken. That is why, my lord, the copy has not been served to us.
What do you say?
So,
Lordship, here, Lordship, there are two PS case, Lordship. One is PS.
You are praying for quashing only one.
quashing for both.
For both.
Yes.
Lordship, in the
Because the petitioner number 1 filed the first FIR, lost the first FIR against the petitioner number 2. And the second one in page number 13 is the counter FIR filed lost by the petitioner number 2. That is why now, since we are in the
Petitioner number 1 is a constable.
one is constable and the
He is a sub-inspector of police.
yes, SI.
Assistant sub-inspector of police.
Yes, madam. Assistant sub-inspector. So since we are in the same department, we have amicably resolved the matter.
Other wants to say something?
Lordship,
What do you want to say?
Lordship, I am submitting that, Lordship, there's two PS case number 8 and 11, Lordship. In the PS case number 8, there's two section 332 and 353, whereas one is compoundable, one is non-compoundable. Both are non-compoundable, but in the PS case number 11, the both are compoundable.
Which one?
PS case number 11 to the 24, which is
PS case number?
341, 11.
11.
Yes,
Lost
given
by the
case number.
petitioner number.
11 are compounded. 11 is
Yes,
compounded.
both are compoundable.
Yes.
Both are.
Yes, Lordship.
Then why quashing?
My lord, in case of this petitioner number 1 in
In the
353, my lord. This is non-compoundable.
The one PS is the non-compoundable loss.
But the 1124 is compoundable, 341 and 323 only.
Yes,
Ma-
Lordship.
This is compoundable, you compound it in the trial court. If charge sheet is filed. I will pass it only, this one.
ma- All right.
Alright.
May I please, Lordship?
Yes.
Lordship, this is an application under section 528 of BNSS for compounding of FIR arising out of
Where is that? Fine.
Lordship, page number 19 of my application.
19.
Lordship, here in this case, the petitioner number 1 is the accused person and petitioner number 2 is the complainant. Lordship, the petitioner number 1 is the husband of the complainant victim.
So they are both husband and wife.
Yes, both are husband and wife. The case,
Application, I bring your.
yes, page number 19 is the type.
Please
of-
read the FIR.
Yes. To the officer PS Sijusa District, Pake Kesang, Arunachal Pradesh. Subject complaint against Sri Logotayam under domestic violence, physical assault and cruelty. Respected sir, I am to bring your kind attention that I am Mrs. Palatayum, wife of Sri Logotayum, village Dorlang, POPS Sijosa, district Pakekesang. The complaint is against Sri Logotayam for repeatedly assaulting and domestic violence on me for the last week.
Now you have compromised now.
Yes, Lordship. Both the husband and wife, they have already compromised the matter. Page number 48. This is the settlement compromise deed between the petitioner number 1 and petitioner number 2, Lordship.
Page number?
Page number 48 of my application, Annexure 5. May I read?
Okay, I hold you to see.
Yes, Your Lordship. This, since 498 is there, Your Lordship, this matter can be quashed, Your Lordship.
It is quashed.
Yes. Deeply obliged.
Obliged, Your Lordship.
May I please, Your Lordship? It's an application for disposal of representation. So my representation is page number 30. Page number 30, my lord.
30.
Yes, 30. Annexure 2. So by filing this application, I requested to consider my promotion from ASI to SI with effect from 26/8/2020.
The representation is considered or not?
Not considered till date. Till date. That's why for consideration, consideration is necessary because I am entitled to be considered. Because due to non-consideration of my application representation, I am superseded by some police officers who were junior to me, who were under my, who were done their probation under me. So at this time, notice may be issued, my lord.
Notice. Okay, I will issue notice to them.
Yes.
Same person. About this matter.
My lord, we are entitled because our promotion was not considered as per our seniority basis.
But the court has already held that.
No, my lord, it was another cause of action. At that time, it was another cause of action, which was dismissed later on.
Claiming for promotion is not a fundamental right.
Yes, it was there. We are already promoted, my lord.
The representation is of 9 February 2023. It was the part of the representation law.
Another representation latest recently, para 670.
Now, without making awareness about this how this representation is maintainable, this case to be dismissed with cost.
At that time, we were not promoted, my lord. But later on, another representation is pending, which was preferred by the petitioner on October 2024. It was still pending. For same cause of action, common grievances.
Your reputation is not maintainable because of this order. Then I will give one chance. Heard Mr. Eve Deka, appearing for the petitioner. Heard Mr. I forgot your name.
Yes, sir.
Yes. If ready for the respondents. List this matter after 4 weeks. On the next date of listing, the maintainability of this rate petition
Yes,
shall be
ma'am.
considered in view of the order of this court dated 18/05/2023, passed in WPC 235 of 2023. Okay. Number 38, on this matter. You want to withdraw it?
My lord. Yes, my lord. The parties are not interested, my lord, to pursue.
Is there any interim order pending?
Yes, there was interim order, my lord.
Mr. D. Soki, the learned counsel appearing for the petitioner. Subject to his instructions to withdraw this
My lord.
writ petition. Accordingly, the writ petition stands disposed of on withdrawal. The interim order passed earlier stands vacated.
Oh, bless.
Number 7.
May I please, your lordship?
Yes.
My lord, for Arunachal Pradesh Civil Service, there is the entry point is the APCS, that is Arunachal Pradesh Civil Service entry grade, otherwise also known as circle officer. For that, lordship, 80% is by direct recruitment and 20% is by lateral entry. People serving in the state of in the departments, in various departments and group B posts, they are entitled for lateral entry, subject to SCRs and subject to interview. Now, lordship, in 2017, the petitioners, along with 14 others, were shortlisted for interview after the SCRs and everything were found in order, lordship. Now, lordship.
For lateral entry.
Lordship?
Lateral entry.
Lateral entry. What happened is, lordship, earlier we were not selected for the lateral entry because they introduced some new requirement which was not there in the earlier process. That is why we had approached this Honorable High Court. This Honorable High Court allowed the petition and directed the government to consider our case for promotion. Thereafter, that judgment was challenged by the respondent, state respondents, and the writ appeal was also dismissed by this Honorable High Court. Now, what happened is, consequent to that, we were given appointment and we have been serving since 2021. Now, lordship, the problem has now arisen in the sense that 13 others who were appointed in terms of that 2017 recruit, we would also have been appointed had they not done it in an illegal manner. By the grace of this Honorable High Court, we were given appointment later on. But lordship, we were given the seniority, but because our date of appointment is 2021 instead of 2017, they are now refusing to give us promotion, saying that you have not completed 5 years of, from entry grade, it is senior grade, APCS. For that, as per the recruitment rules, 5 years service is required. Now, admittedly, since we were appointed in 2021, In fact, if we were appointed in 2019 in terms of the learned single judge order, then also we would have completed 5 years. Now the problem is in the seniority list, they have placed us ahead of those officers appointed by the recruitment in 2020, although we were appointed in 2021. But now the problem is because our names are our appointments are with effect from 2021. We are, first of all, we will not be given promotion. Secondly, there is a high chance that officers appointed in 2020 might, in all probability, challenge, if any, challenge our seniority if anything happens, if promotion comes up. So we had prayed in 2021 itself. On 16/11/2021, we were given promotion. Within 1 month, we have made a representation to the government, kindly give us appointment with retrospective effect from the date our other who were appointed as per the recruitment rule of 2017, kindly give us that date. It was not given. Now the problem has cropped up. Just recently, they had given a communication for considering for promotion. They had given us to submit NOCs, SCR, that sort of thing, Lordship. That is page 99. But Lordship, when we tried to submit, they told us that there is no point in you submitting because you will not be given promotion in view of the fact that you have not completed 5 years of regular service. Now, Lordship, our prayer is that we may be given appointment with retrospective effect from 2017 so that all these issues can be sorted out. Number one. Number two, that the seniority list in the entry in the seniority list may be corrected. Lordship, and in the meantime, Lordship, since they are now trying to go for promotion in senior grade, some 4 posts may be kept vacant for us. We may be considered on a later date.
Urgency is not there.
Now, Lordship, in view of that, Lordship, in view of page 99, Lordship, they have issued this. Lordship may see page 99. Here, our name is also there, of course, but we have been told we will not be given. This is 5th February 2025. This is a communication issued to many of us. Lordship may see the next page. In serial number, Lordship, 25, 26, 27, 28, our names are there. 5th February 2021 in page 99. In page 100, it is the communication. Furnishing of NOC, workplace and home district regarding. It is hereby informed that the promotion cases are to be processed shortly. You are therefore requested to furnish the NOC from workplace and hometown along with details of posting places since inception duly countersigned by concerned DCs, ADCs for obtaining vigilance clearance at the earliest. This was in February 2025. So, Lordship, they may do this exercise anytime now. Of course, we don't have any instructions on that.
Then wait for some time.
Lordship.
RMS and Duncan, preparing for the petitioners. Your senior government.
Yes.
Particular senior government students preparing for the respondents. Issue notice, no formal notice is required to be sent. That's because the learned council preparing for the respondents has accepted notice. List after 4 weeks for admission hearing. On the next date, the prayer for interim order shall be considered.
4 weeks, Lordship.
Interim order.
Oblige.
Item number 8.
My lord, am I audible to my lord?
Yes.
Sorry.
Yes.
Yeah, my lord, the GST laws in relation to a proposed demand and recovery in a transaction where bottling services are provided to a brand owner of an alcohol beverage brand. My lords, on this identical issue, there are other interim orders of this honorable court. My lords, on the very issue in question, there are two earlier orders, my lords. My lords would see, please see page 83.
Page number 83.
This is an order dated, my lords, Annexure 3. This is an order dated 12th of July 22. This is for another identically placed bottler, my lords. May I just invite my lord's attention? May I just read para 2? It is the contention of the petitioner that apart from the fact that the demand is barred by limitation, sorry, my lords have page 83?
Yes, yes.
I'm reading para 2 at page 84.
Yes, yes.
It is the contention of the petitioner that apart from the fact that the demand is barred by limitation, even on merits, the demand is bad in law for more than 2 counts. The attention of this court has been drawn to the order of the board dated 30/10/2009 by which the brand owner surplus has been held to be out of the purview of service tax. The learned counsel has also drawn the attention of this court to an order of the Honorable Supreme Court in which a decision in that regard which was carried on appeal by the department was dismissed. The attention of this court has also been drawn to the law relating to pure agent. By drawing the attention of this court to the impugned order, which by reply of the petitioner has been rejected, learned counsel has submitted that none of the relevant factors have been taken into consideration and not following the instruction of the board itself is without jurisdiction, which would make the order entirely bad. My lords would then kindly, and my lords would see that the issue of maintainability was raised. I responded by referring to the Supreme Court judgment in Indian Oil to say that where a order is contrary to a board circular, it is void ab initio. And my lords would see then that at para 8, we were granted interim protection in the nature of no coercive action. My lords has seen that. My lords, the issue of maintainability then came up and by an order of 28/7/23 passed by Justice Devashish Barua. My lord, that order is available with the counsel in court. She could just hand it over. My lord, the issue on maintainability was fully argued, including reference to judgments of the Honorable Supreme Court. Would my lords please see paragraph 5? Taking into account that the issue involved here is purely a legal issue, the court is of the opinion that it would be in the interest of justice to decide the said legal issue rather than to dismiss on the issue of alternate remedy. So, my lords, this was the reliefs passed in the first petition. There is also a subsequent petition, my lords, before the Itanagar bench. My lords will see that at page 80. Sorry.
Yes.
Does my lord have that? This is Justice Sema, order of 21st of August 24, my lords. This is, my lords would see, this is for the period April 17 to June 17, which is also part of the period here. And here also, my lords would see over the page, on the last page, it says, in the interim, considering the submission made by the learned counsel for the petitioner and the materials available on record, the order and original passed by the principals shall remain suspended till the next returnable date. All these matters now are, my lords, fixed for final hearing. before the Itanagar bench. So this, my lords, is the identical issue, but for another assessee. The impugned order, my lords, will see is at page 53.
Yes.
And if my lords would please see page 59. There is a table there, my lords.
Yes.
And my lord sees over there, the very first item is brand owner surplus. My lords have that.
Yes.
Now, my lords, that brand owner surplus is really the predominant amount, as my lords would see, because this demand is for the period of 1718 to 2021. There are several other elements, many of which are also covered in those earlier orders. And my lords, on this issue of brand owner's surplus, my lords, my lords have seen that.
Yes.
May I request my lord to please go back to that compilation which was given by my learned friend. Would my lords in the compilation please see page 12 and 13?
Yes.
In that, my lords, would please see para 1. It may be recalled that vide the Finance Act of 2009, the definition of taxable service, namely business auxiliary service, was suitably amended so as to include manufacture of alcoholic beverages on job work. In practice, the brand owners of the alcohol beverage get the products manufactured on job work basis. So I am a job worker, my lord, just as the others were. Under a contract manufacturing arrangement with distilleries having facility to manufacture such beverages. In trade parlance, such job workers are called contract bottling units. Para 2, my lords. Under section 67, service tax is chargeable on the gross amount charged by a service provider for providing taxable service. As per the board, the gross value as per the invoices includes the following elements. Please see serial number 7, my lords. Surplus or profit retained by brand owner. My lords have that.
Yes.
Which my lords also saw as the first item in the table. And my lords come to para 4. For the removal of doubts and with a view to avoid disputes on valuation, it is clarified. My lord sees para 4.
Yes.
Would my lords please go over the page to subpoint D?
Yes.
Similarly, the surplus profit earned by the brand owner being in the nature of a business profit, which falls within the purview of taxes, it will not be charged to service tax. GST.
Yes.
So, my lords, based on the fact that this was, now if my lord sees the next page, page 14, there is a judgment of the Honorable Supreme Court, my lords, in Indian Oil Corporation. Sorry, my lord.
Yes.
Is my lord able to see page 14?
Yes.
Indian Oil Corporation. My lords, this goes into what is the impact of a board circular when the departmental officers don't follow it. Like my lord saw in the circular, it said you can't tax brand owner surplus, it will only be taxed to direct tax, income tax. So the Supreme Court considers, my lords, all of the judgments of the earlier benches of the Supreme Court. Please come to internal page 17, para 12.
Yes.
Please see in para 12, subpoint 3. A show cause notice and a demand, contrary to an existing board circular, are ab initio bad. My lords have that.
Yeah.
So, my lords, it is on this basis that in the other matters we got a stay. Also, my lords, please see page 22. My lords,
Yes.
have 22. One of the
Yes, sir.
other job workers, my lords, had also received such a demand. They went to the tribunal, they succeeded. That tribunal order, my lords, in the case of this particular other job worker called BDA, went to the Supreme Court. Page 22, my lords.
Yes, yes.
BDA, they say that the Honorable Supreme Court, comprising of the bench of Chief Justice H.L. Datu and Justice Amitabha Roy, after condoning delay, dismissed the civil appeal filed against the Sestat final order. My lord sees the Honorable Supreme Court's order, delay condoned, para 4, my lords, having carefully gone through the records and the hearing, learned counsel for the appellants, we are of the considered opinion that appeal being devoid of any merits deserves to be dismissed and is dismissed accordingly. Now, my lord sees what the tribunal order was, that is reproduced below. And may I just point out in that para, the very last two lines to the right, my lords, the sentence begins, in view of the CBEC letter dated 30/10/2009, which my lords just saw. Surplus profit earned by a manufacturing company or brand owner is not chargeable to service tax. So, my lords, the board has said it is not chargeable. The Honorable Supreme Court has endorsed it is not chargeable. But in these demands, it is still raised. Just as it was raised in the other two matters where I showed my lords the orders. So, my lords, what we are praying is, my lords may consider following the earlier orders, grant us protection against coercive steps like Justice Mehdi did, and this can be listed as part of the group for final hearing, my lords. Justice Mehdi's order is at page 83, my lords.
Yes, I have got it already. Yeah, who is for the respondent?
Your Lordship, I'm appearing on behalf of DSGA, Mr. M. Kato, for respondent number 1. So, Lord, as far as I have not received any instruction for from the DSGA, so Your Lordship.
My lords, they may be permitted to file the affidavit as was done in the previous orders. In the meanwhile, we may be protected, my lords.
Heard the letter, Senior Counsel, Mr. Rohan Shah.
Yes, my lords.
Appearing for the petitioner. Heard, Mr. What is your name?
Your Lordship is K. Terry.
You are appearing for
Respondent number on the behalf of Mr. M. DSGA.
Respondent number both.
No, sir. Your Lordship 1.
Respondent number 1.
Yes, Lordship.
Union of India.
Yes, Your Lordship.
Appearing for a Union of India. Who is for CGST Additional Commissioner? Issue notice. No further notice is required to be sent to the respondent number 1 as because Mr. So-and-so has accepted notice. Extra copy of the petition shall be provided to him. The petitioner shall take steps for service of notice upon the respondent number 2 by registered postage agent. You heard the learned counsels of both sides in the matter of a prayer for an interim order. This court is of the opinion that the matter involves a legal point which warrant a thorough examination. Therefore, it is hereby directed that where is the notice?
Whereas the impugned order is at page 53.
53. I don't understand in the matter of a prayer for interim protection. Since the matter involves a legal point which warrants a thorough examination, this court hereby directs that no course of action shall be taken against the present petitioner in respect of the notice number.
My lords, order in original number 31. Order in original number 31.
Page number 31.
Yeah. Order in original number 31 dated 3/2/25. Page 53, my lord.
Okay, 3. No course of action shall be taken against the present petitioner in respect of
Order in original number.
order.
In original number, my lord,
Order
will
in original number
31
31
/ CGST
slash
CGST.
CGST slash ADC
That's right.
slash ITA slash 2024 dash 2025
Yeah. Dated 3/2/25, my lord.
dated 03/02/2025. List after 4 weeks. Okay.
Grateful, my lord.
Okay. Yes.
May I please, your lordship? Lordship, before I take your lordship to kind attention in the annexures, lordship, the case of the petitioner is that, lordship, there is a scheme called MG Narega, lordship. Mahatma Gandhi National Rural Employment Guarantee Schemes, lordship, which is promulgated under the National Rural Employment Guarantee Act 2005, lordship. And this scheme has been implemented in the entire state of Arunachal Pradesh, lordship.
Yes.
Lordship. Yes. And thereafter, lordship, the government of Arunachal Pradesh, lordship, in order to for the proper implementation of the schemes, lordship, different categories of the contractual employee has been appointed, lordship. Now the petitioner, lordship, she is being qualified for the computer assistant, lordship. She applied for the job, lordship, and she has been appointed by the respondent number 2, that is the director of the rural development, lordship. And after your lordship will find the appointment order at page number 28, lordship, Annex C, lordship.
Was she appointed on contract?
Yes, lordship.
Yes.
Yes. She was appointed on 5/3/2025, lordship, by the respondent number 2, lordship. And the formal appointment order is supposed to be given by the deputy commissioner of the concerned district, lordship, that is the Upper Subansiri, lordship. When the petitioner, she visited the office of the deputy commissioner, lordship, to join to obtain a formal appointment letter or in pursuance of this appointment letter, lordship. The deputy commissioner has flatly refused her and stated that since the vacancy which she has been appointed from the respondent number 2, lordship, that has been already taken by the respondent number 6, lordship, without following the due process of law, lordship. Now I have run from the pillar to post to obtain the order of the appointment, lordship, by which the respondent number 6 has been appointed, lordship. The illegality has been done by the deputy commissioner. They are in order to conceal them, lordship, they refrain to provide the appointment order also, lordship. So we have no other option but to file an RTA application, lordship. Lordship will find at page number 29, lordship.
Yes.
After filing of this RTA application to the respondent number 4, that is the deputy commissioner, lordship, we have come to learn that the appointment of the respondent number 6 has been initiated on the basis of UO note issued by the respondent number 7, that is the MLA of the Dumparijo, lordship.
Okay. On the basis of recommendation of the MLA, she was appointed.
Lordship, he was appointed, lordship. That is respondent number 5, lordship. Or respondent number 6, lordship.
Now, how you were appointed? By any examination or like that?
No, lordship. This contractual appointment, lordship, it has to be scrutinized by the PD, that is the project director of the concerned district, lordship. And after that, after obtaining all the qualification scrutinized by the PD, lordship, they send it for the higher level, that is the state government, that is the direct respondent number 2, lordship. Only after the approval of the respondent number 2, lordship, the contractual employees were appointed under this scheme, lordship.
Let the deputy commissioner reply. Who is for the respondents? 4 and 5. Deputy commissioner.
Or this, lordship, at this juncture, lordship, my humble prayer would be, lordship, since there is a gross illegality has been committed by the deputy commissioner, lordship, at least lordship till the next, since they, the government, let the government employee get instruction from the deputy commissioner lordship. Till the, in the meantime, lordship, respondent, appointment of the respondent number 6 lordship, it has to be stay lordship.
No stay order now, because your appointment is also something unnatural.
No, lordship. This, if,
Because was there any advertisement for that post?
no, lordship, this scheme lordship, this scheme, each and every.
There is nothing on record for now, my lord. We have to take instruction, my lord.
You take
Uh,
instruction.
My lordship, in that case, lordship may kindly come to the page number 26, lordship. This is the advertisement lordship has been issued by the
On the
department,
basis of this advertisement, you applied.
yes, lordship. On the basis of this this advertisement, I have applied since I have been qualified for the post, lordship. I have been applied for that. And
This is not an advertisement, ma'am. This is pay fixation.
Pay fixation. Only because of once this has been revised, lordship.
Let them first find the reply.
Yes.
After that, your prayer will be considered.
Yes. Lordship,
Or
in
Mr. T. Garam, appearing for the petitioner. You are appearing for 1, 2,
I am for 1, 2, 3, and 5, ma'am.
1, 2, 3, and 5.
Yes.
Heard Mr. So-and-so, you are government employee,
Standing council, RD.
a standing council,
Rural development.
rural development. Appearing for the respondents 1, 2, 3, and 5.
Yes, ma'am.
And you are appearing for
Election 4 only.
only 4. Heard MS so-and-so, appearing for the respondent number 4. Issue notice. No formal notice is required to be sent to the respondents 1 to 5. As because the learned counsel appearing for them have accepted notice, extra copy of the petition shall be provided to them. The petitioner shall take steps for service of notice of the respondents 6 and 7 by registered post to AG.
In that case, lordship, fixed date may be given, and the next date, lordship, my interim prayer may be considered, lordship. Otherwise, lordship,
You suggest on date.
lordship. In that case, lordship, this matter will be fixed on lordship, 3rd of April, lordship.
Third will be.
My lord is issuing notice of upon private respondents, my lord. 3rd of April.
3rd of April, only the deputy commissioner has to take an instruction whether the appointment of the respondent number 6 has been done as per the guidelines or not, lordship.
Second week, Lordship.
9th of April.
21 April, my lord.
Third will be too early.
Lordship, 9 of April, lordship.
Release this matter on 9th of April. After the respondents who are present today file their affidavit, counter affidavit, the prayer for interim order shall be considered.
Lordship. Deeply obliged.
Number 10. Yes.
My lord, I am agree of non-measurement and non-assessment of my land, my lord. Measuring 18 acres, my lord, which comes under acquired land for Tato hydroelectric project. My lord, assessment and survey was done in 2010, my lord. And as per assessment report, my lord.
No, I have already gone through it.
Yes, my lord.
Today I will issue notice only. Who is for the respondents? State of Arunachal Pradesh Secretary,
Land.
Management, Indian Standing Council. Then you have to issue notice.
Yes,
there is no other. Hard Mr.
LNOC.
LNOC. Appearing for the petitioner, issue notice to the respondents. The petitioner shall take steps for service of notice upon the respondents. How you will send the notice? By registered post.
Yes.
By registered post with AD. List after 4 weeks.
May I please, my lord?
Sworn as a witness, my lord, and 164 statement was.
Yes. Who is for the respondent number 2? Yes, Lordship. You are for respondent number 2.
My lord, in fact,
Where is the FIR?
my lord, prayer is,
Page 17.
yes, my lord, page 17, my lord.
Yes.
Yes, my lord. My lord has seen the FIR, my lord. My lord, in the year 2009, my lord, there was an assembly election in the state of Arunachal Pradesh, my lord. What happened, my lord, in the assembly election, my lord, is the campaign was going on, my lord. The Congress party, my lord, leader, my lord, under his leadership, my lord, he has assaulted the party supporter of TMC, my lord, who was one of the contesting, my lord, party in that constituency, my lord. Against that, my lord, TMC Walker, my lord, led by the its leader, my lord, they filed FIR against the.
Okay, I just, before that, I want to know the reply of respondent number 2. What is your reply?
Lordship, the facts of the matter is that, Lordship, on that fateful day, Lordship, I was going to attend my duty, Lordship, as I am a teacher, as a senior teacher at Government High Secondary School, Teju, Lordship. Out of nowhere, Lordship, when I reached to Thanatinali, Lordship, I saw that there were more than 50, approximately 50% were there, Lordship, who were equipped with some weapons and all, Lordship. So seeing that, Lordship, I tried to call Bazaar Secretary, Lordship. In fact, Lordship, they were demonstrating that they were they were distracting some Sonia soaps is there, Lordship. They were distracting that soaps, Lordship. So, Lordship, Lordship, I was about to call that Bazaar Secretary. In that time, Lordship, this petitioner accused their Lordship, they suddenly came and started beating me, Lordship, out of nowhere, Lordship. Neither, Lordship, I was doing any political this campaign or nor, Lordship, I am associated with any political party, Lordship. So my prayer before your Lordship is that, Lordship, this quashing petition may be dismissed and they let the petitioner may face the trial, Lordship. That's all, Lordship.
Okay, Jeannie, what is the injury report? What type of injury sustained?
Simple injury, Your Lordship.
Simple injuries.
Your Lordship, I will just apprise Your Lordship because one of the accused in this case had settled the matter and the Honorable Court only on regard to that accused had quashed his part of the case, Your Lordship. Your Lordship, because I was also concerned to that effect that if the agreement can be and quashing can be done only on the partly agreement of one of the accused, Your Lordship. Your Lordship will see that the same question was put before the Honorable Apex Court. If Your Lordship will read the third paragraph, Your Lordship.
Yes.
On the legal aspect, the council draw the attention of the court to charge page D to point out that different High Court has taken contrary position on the issue as to whether on the face of compromise with one or few of the accused in the case can be quashed part by the court, Your Lordship. Now that issue is still pending, which is in the next page, Your Lordship. The status of the case is still pending before the Apex Court, Your Lordship. Now, only to that regard, Your Lordship, because one of the point given in the petition for quashing is that one of the accused has already settled and his part of the case was already quashed, Your Lordship. To that effect, I'm placing that order, Your Lordship. Otherwise, Your Lordship, the matter, the complainant has clearly named the accused in his statement, Your Lordship. on the 161, as well as he's named as accused in the FIR, Your Lordship.
Is there any stay order pending?
Yes,
No,
Your Lord.
no, my lord.
Stay order.
No, my lord. My lord, in fact, not, that is not only the my lord ground I am.
Why don't you try to compromise the matter, out of court settlement?
My lord, since my lord, there is, my lord has seen the affair, my lord. There was election, so obviously, my lord, there is political rivalry between the party, my lord. And the petitioner, my lord, he is one of the prominent leader of that area, my lord.
The charge sheet filed or not?
Yes, it has been filed, my lord. It has been filed. My lord has seen the affair, my lord. It says, my lord, there was this group of people, my lord. Mob has attacked the alleged victim, my lord.
Anyway, this is, if he is not agreeing to that, so it will be difficult to quash that matter.
Otherwise, also, my lord, the section, my lord, under against which the accused has been
No,
charged,
for
my
the-
lord,
for the
that
timing- for
that
the
is not
timing, I will-
applicable, my lord, in this case, my lord.
Yeah, for the timing, I will stay the further proceeding of the case.
Yes, my lord.
In between, you try to compromise the matter with him.
Yes, my lord.
Heard Mr. D. Kambu, preparing for a petitioner. Heard Mr. T. Gini, delayed a petition upon the prosecutor for the state of assembly. Heard Mr. G. You are G. Gini. She is T. Gini.
T. Gini.
G. Gini, appearing for the respondent number 2. Release this matter after 4 weeks. What is the case number?
Case number, my lord.
And where it is pending?
It is pending before the CJ, my lord.
Case number?
Case number is, my lord, year case number 46 of 2009, my lord.
Till the next date of listing, the further proceedings of GR case number
46 of 2009, my lord.
pending in the court of the Chief Judicial Magistrate, where?
Teju, my lord.
Teju, shall remain stay.
Much obliged.
You try to compromise this case.
Yes, my lord.
Deeply.
Please, my lord. My lord, here in this CRP, my lord, I'm challenging the order of the additional deputy commissioner, who in a very mechanical manner, my lord.
They filed the affidavit in opposition.
Yes, ma'am.
Do you want to file any objection, reply?
No, my lord.
Okay. Then it will go for hearing. I will admit it, and it will go for hearing.
My lord, I can.
Heard Mr. D. Soki, appearing for the petitioner. Heard Mr.
Amata.
Appearing for the sole respondent. The revision petition is admitted for hearing. Pleadings are complete. This matter, when do you want it?
Anything. Short date. Any short date. After 2 weeks.
No.
Suggest one date after 2 weeks. Is there any interim order pending?
Yes, there is an interim order.
Then list after 2 weeks. The interim order past tense will continue until then.
My lord, this is a joint petition.
Joint,
my lord, but of course, my lord, otherwise the trial, my lord, it is the charges, my lord, it is under 302, my lord.
302, where is the FIR?
My lord, the charge sheet starts at page 15, my lord.
This is the charge sheet. Where is the FIR?
My lord, that it's in the charge sheet, my lord. Trial is already going, my lord. That charge sheet is at
The relevant page is at page number 17, Your Lordship.
17.
Here, my lord, this is a case where, my lord, the petitioner, my lord, under the state of intoxication, my lord. Of course, the petitioner does not remain, petitioner number 1 does not remember, my
I
lord.
mean, that has to be proved in the trial by evidence.
My lord. But what today I'm here before, my lord, but because otherwise that person, my lord, the deceased is my own real brother, my lord. Own real brother. Whatever happened, my lord, it was an accident, my lord. Otherwise, now what is the situation here is, my lord, the petitioner is now looking after the children of the deceased as well.
Even the,
And, my lord, the victim, my lord, the wife of the victim is now living together also, my lord. Now, under this situation, my lord, in the event, my lord, there is some order is passed against, my lord, the petitioner, my lord, petitioner number 1, my lord. Everybody will suffer, my lord. My lord knows under the that system of penology, my lord, it's a reformative as well as penal is also there, my lord. Yes,
let the offense be first proved before the trial court. Then other things will come. Penology and all these things will come later on.
my
Not
lord,
now.
but because basically this is a mercy petition before your lordship.
Mercy petition is like. Okay, how will
Then-
the Soki appearing for the petition? The hard MS TGNI, we learned to the public prosecutor for the state also. Please this matter after 3 weeks.
My lord,
Go
then,
ahead,
does my lord, let this be listed for hearing in usual course, my lord, then.
Please this matter for hearing in usual course. Please this matter for hearing in the usual course.
There's an interim there, my lord. Interim is there.
Is there any interim order pending?
Yes, ma'am.
The interim order passed and will continue till next date of listing.
Obviously.
Item number 15. Yes, yes.
My lord, this is also a criminal petition, my lord. What we understand, my lord, what I humbly understand was a civil proceeding, my lord, has been given a criminal color. And my lord, charges has been framed under
406.
420, my lord.
Please show me the FIR.
FIR is at page 157. But the FIR is, my lord, very longish, my lord. But there are agreements, my lord, from where I can show that it was a business partnership. If your lordship deems it fit, my lord, can it be taken up for disposal, my lord?
It can be taken up.
The petitioner, my lord, is a managing director of a company known as Absolute Bill Concept Private Limited, my lord. Now, if your lordship may kindly have, before the FIR, my lord.
Sorry to interrupt, my senior, my lord. I'm extremely sorry, my lord. I missed this, my lord. I missed this in the.
You are for respondent number 2.
Yes, my lord. I
Tomorrow,
overlooked
my lord.
the
Tomorrow.
Tomorrow.
I have some difficulty, my lord. I'll be
In that case, my lord, like, I don't have a stay in this proceeding. Let the proceedings be stayed, my lord, and let it be.
Let's stay the proceeding.
Yes, ma'am.
Heard Mr. D. Pangi, appearing for the petition. Heard G. Tagore.
Yes.
We learned additional public prosecutor for the state of Assam. I heard Mr. D. Soki, appearing for the respondent number 2. Para. Mr. Soki has prayed for an adjournment on personal reasons. After hearing both sides, his prayer is allowed. Least after 3 weeks. Till returnable date, the further proceedings of, what is the case number?
My lord, Pasigat PS case number 07-2021, pending before the Chief Judicial Magistrate Pasigat.
Where have you mentioned it?
Page 211, your lordship will find.
211.
GR number 7-2021.
211. List after 3 weeks. Till the next date of listing, the further proceedings of GR case number 07 of 2021, arising out of PSG PS case number 07 of 2021, pending in the court of
Chief Judicial Magistrate Pasigat.
Chief Judicial Magistrate
Pasigat.
Pasigat. shall remain stayed.
Well,
Number 6. Yes.
My Lordship. Lordship, this is a joint application for quashing of FIR dated.
Where is the FI?
FIR is at page number 20, Lordship.
Huh?
Page number 20.
20.
20.
Please read the FI with most.
With above cited subject matter, this is your kind in consideration as an action, please.
No, this is withdrawal of the FI.
No, yeah, this 21 is the withdrawal of FIR. And
Okay, where is the FI?
20, page number 20.
Oh, so yes.
20. May I Lordship.
Hmm.
With above cited subject matter, this is your kind consideration and necessary action, please.
Hmm.
I am writing to file a complaint against Sri so and so, that on November 15, 2024, around 9:30 to 10:30, above mentioned persons came to my house located in BSNL complex and brutally beaten me. The brief of the case is that I was having dinner with my family members, and these two above mentioned names came to my house as per my observation and notice. Both were drink too. They brought 4 bottles of beer with them. As they often came to my house to hang out, I welcomed them. While having friendly talk, so and so started saying that you are the reason I got transferred, and he started to use vulgarity and petty languages against me and against some renowned politicians. Even that time also did not say anything. I just ignored, but he didn't stop there. Sri so and so intimidates me. The friendly talk becomes heated arguments. Therefore, I controlled myself and I got up and I was going to the main door, and suddenly Sri so and so hit me with wooden stick and punching me again and again in my face and in my body. I also pinched him back as self-defense, but he overpowered me. Later, my family members came and saved me. That Sri so and so didn't do this kind of act first time with me. Back in days, he did the same with me, but keep quiet, thinking about our relationship. But this repeated the act against me directly, shows his ill intention against me. Today he came to my house to threatening me my life. Tomorrow he can kill me.
Charge sheet filed or not?
No, Lordship.
No, Your Lordship.
Only FIR is registered.
It is there, Your Lordship. It seems that they have also filed a withdrawal.
Withdrawal petition.
And Lordship, they are from same
application
village.
before the IO, Your Lordship.
It can be cost.
Yes, Your Lordship.
It is cost.
Much available.
Item number 17.
Here, Your Lordship, we have shown as a witness, Your Lordship, after granting interim protection by this honorable court, the investigation officer issue a notice and our 164 statement has been recorded. Now this matter become infructuous. Lordship, may kindly grant permission to withdraw this application, Your Lordship.
You want to withdraw it?
Lordship, because the investigation officer shown as witness to the present applicant, Your Lordship.
Oh, so you are shown as a witness.
Please, Your Lordship, witness.
Okay, all right.
Or our 164 statement has also been recorded, Your Lordship.
Okay, all right.
Your Lordship, the interim passed earlier may be vacated, Lordship.
All right, Mr. What is your name?
Maulik Soni. Maulik Soni.
Mori Soni. Heard Mr. M. Soni, appearing for the petitioner. Heard MS L. Hagedila and the defendant public prosecutor for the state of Assam. Fair. Mr. Soni has submitted that earlier this petitioner apprehended that he might be arrested in this case, but later on he was made a prosecution witness. Stop. His statement under section 164 of the CRPC has also been recorded. According to Mr. Moore, under the given circumstances, this anticipatory bail application has become infructuous. Where after hearing both sides, and after considering the circumstances, this court is of the opinion that the present anticipatory bail application has become infructuous and stands closed and disposed of accordingly. The interim order passed earlier stands vacated.
Lordship. Obliged.
Obliged, Your Lordship.
Number 18.
Lordship, on 11, Lordship, I was granted an interim protection by this honorable court.
Did you appear before the IO?
Yes, Lordship. Afterwards, I went before
Is
the
it
IO.
there in the statement?
Yes, his statement recorded, Your Lordship. His custody's interrogation is not required since he is cooperating with the investigation.
Heard Mr.
D. Soikia, Lordship.
D. Soikia appearing for the petitioner. Heard Mr. T. Ate, learned petitioner public prosecutor for the state of Assam. This is an application under section 482 of the BNSS 2023, praying for 3 years bail in respect of Papu Hill PS case number 24 of 2025. Fair. On 11/03/2025, this court granted interim bail to the petitioner and directed him to appear before an investigating officer. Accordingly, he has appeared before an investigating officer and his statement has already been recorded. Fair. Under the given circumstances, this court is of the opinion that since the petitioner has been cooperating with the police investigating officer, he does not deserve to be detained in custody. The 3 years bail application made by the petitioner Sri Takio Taguk, alias Tar TARH Taguk, is allowed. The interim bail order dated 11/03/2025 is made absolute. The CD shall be returned. The bail application is disposed of.
Highly obliged.
Obliged.
Item number 19. May I please, my lord? Since my lord is well acquainted with the facts of the case, I won't be pressing much on the FIR, my lord. Straight away, my lord, if I may take my lord to page number 45. 45.
Your Lordships, I'm sorry to interrupt, but something very unfortunate has happened in this case. My Lords may have the order dated 24/3/2025.
Just a minute.
My lord,
Very unfortunate, my lord.
before he makes a submission, my lord, I want to keep the record straight, whether he has filed a wakalatnama or not.
My Lords may see the order. The CGM's court
Otherwise-
has committed a gross negligence, my Lord. There is an inquiry which has to be called for. This man is no longer in custody. The accused is in Delhi right now, my Lord.
Under what authority
Look
he's
at this
making a
order, my
submission, my
lords.
lord? Under what authority?
My Lord, may
Under
look at
what
this
authority?
submission.
So therefore, the law mandates that you can only assist the PP. You cannot make an
Yes, my
independent
lord.
submission.
No, my Lord, I have judgments on that also. My Lord may quietly have this order, my Lord.
There's a clear judgment of the Supreme Court where you can participate, but you cannot make an independent submission. That's a mandate of law.
My Lord may kindly see this. See this order. It's shocking.
I don't know what they are trying to do, my lord. Even not
My lord,
allowing
this
me to
is
make a
an-
submission
This is an order
without
of
any
the
wakalatnama.
chief-
He's making a submission, my lord.
This is an order of the Chief Judicial Magistrate who retrospectively dismisses remand in complete defiance of Section 480.
My lord, Is this the procedure, my lord?
That is a different matter.
Unless and until I make a submission, how come he's making a submission without any authority, my lord?
My lord, kindly see this. This man is no longer in custody.
Please
How
allow
can
me
a
to make a
bail?
submission, thereafter you can make a
He is in
submission
Delhi.
if law permits you.
No, let him say no. Is it denied that he is in Delhi,
Since,
not
my
in
lord, there
police
were
custody?
multiples
I
of,
will hear the petition only.
since there were multiples of anticipatory bail application, my lord, in respect of the present case. Thereafter, my lord, all the anticipated bail applications were rejected. Eventually, my lord, the matter came up before the Honorable Supreme Court, and the observation of Honorable Supreme Court is in page number 45, my lord. If I may read, my lord.
45.
Having heard learned senior counsel for the petitioner at a considerable length, we do not find any ground to grant pre-arrest bail to the petitioner. The special leave petitions are accordingly dismissed. However, if the petitioner surrenders and applies for regular bail, such an application shall be considered as per its own merit without being influenced by the observation made by the High Court. The impugns order, pending application, if any, shall stand disposal.
Oh, yeah, this is the same petitioner.
Yes, my lord.
Tabing Lamgu.
Yes, my lord. He's a practicing lawyer, my lord.
He's a lawyer.
Yes, my lord. He's a practicing lawyer of this Honorable Guwahati High Court. And thereafter, my lord, in compliance of the order of Honorable Supreme Court, my lord, I have surrendered before the arresting authority on 19/3/2025. Now, if I may take, my lord, to page number 46, my lord. That is the arrest memo.
What are these photographs?
The serial number 7, my lord. Date of arrest is 19/3/2025. Page number 46, my lord. NHS 7.
Yes.
Date and time of arrest 19/3/2025.
Okay, all right. So show me the FIR.
FIR, my lord. The FIR is at page number, starting from page number 19, my lord.
The operative part.
Authority part is at page number 24, my lord. May I read, my lord?
Yes.
Subject FIR. I won't read the name of the contents of the name.
Your name is in number 2.
Number 2, my lord. With most respect and humble submission, we are to inform you that our father, Sri Takum Dada, went to his agriculture farm at Bangdu, Moirang on 13/12/2024, which is in the bank of Pachi River. That night, he did not return back to home. Therefore, we reported to your good office and submitted a missing report, white letter number so and so. So, in the very same day, we, along with the police personnel, went to his agriculture farm at Bangdu, Moirang, and found his dead body struck on a rope in middle of Pachi River. The body was brought out of the river, and it was carefully examined and recorded in videos and photos, which is being submitted herewith. As per the site verification, our father was caught, dragged, and cut with machete dao by the above mentioned person. After killing our father, dead body was again dragged to the river and thrown into the river. The marked dragging was clearly seen from the incident spot up to the river. The body had lots of cut marks in head, neck, right shoulder, right arm, and palm of left hand. It seems that the finger of my father was chopped off first and then dragged to the riverside and brutally murdered thereafter. It is suspected that some Dada people are also involved in the case by tracking the movement of our father and guiding those accused to the agriculture farm of our father where he was murdered. Fact of the story, my lord. Last year, on 15 December 2023, our father and late Longya Lamgu had a dispute regarding Mithun ownership case. During this dispute, late Longya Lamgu attacked our father with local machete, local dao. In self-defense, our father injured late Longya Lamgu. Subsequently, the case was registered, White SEPA PS case number so-and-so, under section so-and-so. In the same night, that is on 15/12/2023, all the above mentioned accused damaged Gojam Dada's commercial building and set fire to government quarter allotted to his wife, namely so-and-so, so-and-so. You are requested to recover these properties and amounts from the above listed accused. The CCTV footage of the incident was seized by the then IO. Late Longya Lamgu was treated in Guwahati-based hospital. He's my father, my. On 29 April 2024, that is after a long gap of 4 hours and 5 months of incident, late Longya Lamgu died due to some other reason in Trim's hospital, Naharlagun. From that day onwards, the above mentioned sons and brothers of late Longya Lamgu was in a plan of revenge. Accordingly, they executed their plan on 13/12/2024, most probably forenoon. One white Scorpio, one black blue Thar, along with white Scorpio of Sri Tabing Lamgu was spotted on the day of the incident at around 10 a.m. at Kote Camp, which is in the nearest road point of the incident place. This is a pre-planned cold-blooded murder by the above mentioned accusers. They brutally killed our father with well-planned conspiracy. It is an incident of rarest of the rare case, and above mentioned accused person may be arrested at the earliest and highest level of punishment may be given. Therefore, we request you to register the case under appropriate section of IPC and investigate by arresting all the above and below mentioned person. It is learned from the reliable sources. This is the FIR, my lord. Basing on this FIR, my lord, the
Your
case
Lordship,
was
I have
registered.
placed the CD, Your Lordship.
Are there any eyewitnesses?
No, Your Lordship, this has been, Your Lordship, the tracking of the mobile phone of the accused, Your Lordship, was made. The CDR, there is a evidence of CDR, Your Lordship. Your Lordship, if I may, Your Lordship, there was a
If I may-
direction
If
from.
I may, my lord, complete the submission. Basing on this FIR, my lord, investigation was carried out. And in respect of this case, my lord, there were multiple anticipatory bail applications which has been filed before, my lord. Initially, interim protection was granted, but thereafter, my lord, after perusal of the case diary, the interim was vacated. Now, thereafter, my lord, they have filed an application before the Honorable Supreme Court. The Honorable Supreme Court has also dismissed the petition with a direction to surrender before the arresting authority. Accordingly, in compliance of that, my lord, we have surrendered on 19 to 2025.
This is incorrect, my lord. I'm sorry
Yes,
to
Your
interrupt.
Lordship.
This is
If I may-
incorrect. He is
if
not
I may-
in custody as
If I
of
may,
now.
Your Lordship. Lordship, on 19, he has surrendered, Your Lordship. I have also placed the same before the Your Lordship. On 19, he was, there was a complaint of medical emergency, Your Lordship, and if Your Lordship will see the CD, Your Lordship, a direction was put to the DMO SEPA for constituting a medical board and examining the accused, Your Lordship, which is on the next page, Your Lordship. On 19 itself, a constitutional board was constituted, Your Lordship, and he was medically examined, Your Lordship. On 19, that is on the third page, Your Lordship, the patient was, the accused was declared as not fit to be kept in the custody, Your Lordship. Subsequently, thereafter, Your Lordship, he was taken to TRIMS as per the direction of the board, Your Lordship. The board on the TRIMS on 23/2025 has referred him to Medanta, where he is taking his regular therapy of the disease, Your Lordship. Thereafter, Your Lordship, an intimation letter was given to the CGM intimating him that the accused has been referred by the TRIMS to Medanta, Your Lordship. Now, subsequently, Your Lordship, I have also flagged marked. Today, there was an order from the court of the CGM, Your Lordship. If Your Lordship, I have flag marked it, Your Lordship. The orange flag mark.
Yes.
Yes, if I may read, Your Lordship. The accused so-and-so was produced before the executive magistrate SEPA on 19/3/2025 with a prayer to remand the accused under police custody for a period of 3 days in connection with present case as the undersigned was on leave. Upon perusal of the case, it is found that on 19/3/25, I of the case was prayed for police remand of the accused so-and-so before the executive magistrate SEPA, but as per the medical report of the accused, he was suffering from non-constructible Berger's disease, peripheral arterial disease, and other related conditions. Therefore, the executive magistrate has directed the IO to obtain a fitness certificate from the board of doctors of the district hospital SEPA to enable him to address his prayer. Accordingly, a medical board was constituted and they declared the accused unfit to be kept under custody and recommended him to TRIMS for further treatment. On 23/2024, the IO had submitted intimation letter wherein he stated that the accused was admitted in TRIMS for further treatment, and on 23/25, the doctor who was attending the accused at TRIMS has again referred the accused to Medanta Hospital, Delhi for stem cell therapy. Hence, the accused left Delhi for stem cell therapy. Based on the report of the doctor and the IO, the accused required his treatment and he is not fit to be remanded under custody. Therefore, the IO is directed to produce the accused as and when he is recovered. Now, there was a prayer of 3 days for police custody, which was rejected by the IO on the ground that he has been referred by TRIMS to further treatment, Your Lordship. Now, I have also the status report. If Your Lordship sees the status report.
Manoj, I'm sorry to
which I
interrupt.
have, which I
Manoj,
have,
this order is illegal. Please
which I
see
have-
section 187 of the BNSS. Manoj, I'm sorry to interrupt. This order is absolutely illegal. It is
Lordship-
remand. The remand magistrate must have the person in front of him. Section 187
lord,
subsection 5 of the
My lord,
BNSS.
since I'm
I'm
on
sorry, my
humanitarian
lord, I did
ground,
not interrupt my
but
friend. My
if they
lord,
are
I'm
pressing on
sorry.
that, solely on that ground, I'm
No,
entitled
no,
to
my
bail,
lord, I'm sorry. This
My lord, he has been
report
taken into
has to be
custody on
brought-
19 to
My lord, how
2025.
can a person be in
And till
custody
today,
when he's
there's
in
no
Delhi?
remand.
Your Lordship, I.
Whether a person can be extended and kept into custody beyond 24 hours without a remand.
Your
I'll
Lordship,
come on to that
Your
also.
Lordship, I may
My
be allowed
lords,
to.
please
There's no
see
remand
this.
at all.
Give a status of the update, Your Lordship. Your Lordship, the status report has also come and all, as well as the IO has also given a bail comment, Your Lordship. In the bail comment, Your Lordship, though there is a reflection that the accused, while surrendering, has given his statement, which is not annexed with the CD, Your Lordship. So the statement of the accused has to be in the CD, Your Lordship, which is not present in the.
My lord,
But
I'm
procedurally,
on
my
three
lord,
grounds, my lord.
remand procedures, the rigors of remand have to be
My lord,
followed.
if
Section
I may take my lord to
187,
page number
please.
74, my lord. Page
My
number
lord, may first
74
see
of
section
the petition.
187. My lord, may see section 187 of the CRPC of the
74.
BNSS. Please, my lord.
74, my lord.
What is 74?
Is the order of the magistrate, my lord. After the arrest, in compliance of section 57, my lord, within a period of 24 hours, I've been produced before the magistrate, my lord. Thereafter, my lord, this order has been passed, and this order has been passed on 19/2/2025. Till today, I'm officially under custody, but there's no remand order.
My lord, may please
There's a
see
clear
section
violation of
187.
section
187,
57
my lord.
and a clear
The
violation
law-
of article 22(2) of the Constitution of India, my lord. This entitles me for a
My
bail,
lord,
my
may
lord.
please see section 187. I will answer this.
My only
I will
request,
answer
No,
this.
If I may,
my only submission is that there is no specification as to the statement that has been recorded after he had surrendered, Your Lordship. Otherwise, on medical ground, Your Lordship, the medical board was constituted, Your Lordship, and subsequently he was referred to the for medical treatment, Your Lordship.
My lord, may please see a
there-
Supreme Court judgment, my lord, on this, categorically on this. This man is currently not in custody.
I
On the 21st, when he left for Delhi.
What is submitting, my lord?
No,
He's
my lord,
arrested
just
on
I am
19, my
making a
lord.
very, yes, I'm making a very serious submission. My friend will allow me to make this very serious submission. Para 13. This man is currently not in custody. On the 21st, he left for Delhi without police personnel, without a transit remand order. The magistrate in this case, my lord, under section 480 of the BNSS cannot grant bail. Please
In
have
that case, he's
BNSS,
making an
my lord.
allegation against the prosecution,
Yes,
my
I
lord,
am.
not against
I
me.
am.
It's
Yes,
unclear.
my lord.
Where he was arrested?
Please.
19/3/2025.
I will.
Wait, Delhi or
No, my lord.
He was arre-
He has surrendered
surrendered.
before the SEPA PS, surrendered to PS, my lord.
Sepa PS?
Voluntarily, my lord, in compliance of the order of Honorable Supreme Court.
My lord, please have section 187 of the BNSS. Please, my lord, section 187, subsection 4 and subsection 5 categorically says this. On the 21st, when he left for Delhi, it was mandated that he be produced back to the magistrate, and the magistrate had to take a call whether he can travel to Delhi or not. After the 19th order is very clear. The 19th order says, please get a medical
My lord, may
board
kindly
done and
pause
get
him for
him
a
back
minute.
to us.
Your Lordship,
Mute him, my lord.
if I may, Your Lordship, if I may at least be allowed to.
No, I'm sorry, my lord, the petitioner cannot direct the court to mute me like this.
Yes, I may, Your Lordship. The point that has been taken by the complainant, it seems, Your Lordship, if I may refer to 187, Your Lordship.
Page number?
186,
Not page,
section
Your Lordship
187,
will-
my lord.
At least,
Of
sir,
BNSS.
excuse me, sir, I'll just have my submission, please. Your Lordship, the submission that is being made, if I can understand to that point, Your Lordship, that if Your Lordship will see the CD, he had surrendered on 19. 19, Your Lordship. The last line of the 19 says, in the light of the medical condition, the investigation officer is directed to obtain a fitness certificate from the board of directors at the district hospitals, SEPA, and produce the accused before court for further proceeding. This was the direction. Now the board has given that he was not unfit, Your Lordship. Thereafter, an intimation letter was given to the CGM stating that the TRIMS has referred him to Medanta and therefore necessary action was deemed fit. the submission that is being given is that he was not subsequent to 19/3/25 order. There is no order of the magistrate taking into consideration the reference of the trims, medical trims. There was no order until today, that is on 24th. So as far as I can understand, the submission is that the magistrate has not referred him to, after perusing the trims order for referring him to Medanta. There is no specific order as such of the magistrate until today. That is on 24/7 when he has already left. That is only the submission. My submission, Your Lordship, my submission, if I may be allowed, because I'm producing the CD, Your Lordship. My submission is that at this present, the bail comment has been clearly given, Your Lordship, where prima facie case of the accused has also been reflected. However, my prayer is that since the accused has already given his statement, Your Lordship, after he has surrendered, that is not placed in the CD. That is a requirement, because after he has surrendered, Your Lordship, there is a re-interrogation of the accused, which is not a part of the CD. And therefore, I seek time from this Honorable Court to place this, place the same before in the CD, Your Lordship. Because that has to be reflected to come into a prima facie case if the accused is to be given bail or not. Otherwise, I don't have any prayers.
We all have to follow the law. Please see section 187 of the BNSS. Please, I'm beseeching the court to look at section 187 of the BNSS, specifically subsection 4 and 5. Please.
What is the section?
Section 187, my lord. This is akin to the earlier section 167. This deals with remand. Subsection 4 and 5 of 187. So subsection 4 says a person has to be produced, and subsection 5 says you have to give bail. Magistrate cannot give bail, CGM cannot give bail under section 480. Please see 4 and 5.
If we go by that submission, my lord, right now I'm entitled to bail because there's no remand order till today. Today, remand order has been passed, and I have been under custody beyond 24 hours. That entitles me for a bail, my lord.
No, it doesn't.
Clear violation of.
After you had surrendered,
My lord.
You were produced before magistrate or not?
Yes, my lord.
Then what the magistrate did?
Magistrate has given a direction for medical, my lord, to verify that. But however, my lord, whether I can be kept in custody beyond 24 hours, that is the issue, my lord. Officially on record, I'm still under custody, my lord. Whether I'm staying at home or whether I'm at police custody, my lord. If for a time being, my lord, if I may take my lord to page number 46, my lord. (46) of the petition, my lord.
Yes.
This is the arrest memo. And now, my lord, the law mandates that as soon as I am being arrested, the grounds of arrest has to be given to me and my relative in writing, my lord. This has been recently, my lord, on 7/2/2025. The Honorable Supreme Court has made an observation. If my lord allows me, my lord, I'll place the authority.
Bihan Kumar.
That is judgment, my lord.
Bihan Kumar's case.
Bihan Kumar, my lord. Has to be given to me in writing. Straight away, if I may take my lord to page number 14, my lord. Observation of the Honorable Justice Koteshwar Singh. If I may read, my lord. I had the benefit of going through the draft opinion of my esteemed brother, Honorable Justice Abe S. Oka, and I concur with the analysis and conclusion arrived at. However, I wish to add a few lines in supplement to the aforesaid opinion. The issue on the requirement of communication of grounds of arrest to a person arrested is mandated under Article 22(1) of the Constitution of India, which has also been incorporated in the Prevention of Money Laundering Act 2002 under Section 19 thereof, has been succinctly reiterated in this judgment. The constitutional mandate of informing the grounds of arrest to a person arrested in writing has been explained in a case of Pankaj Bansal Supra so as to be meaningful to serve the intended purpose, which has been reiterated in Prabir Burkayasta Supra. The said constitutional mandate has been incorporated in the statute under Section 50 of the CRPC, Section 47 of BNS. It may also be noted that the aforesaid provision of requirement for communicating the grounds of arrest to be purposeful is also required to be communicated to the friends, relative, or such other person of the accused as may be disclosed or nominated by the arrested person for purpose of giving such information as provided under Section 50A of the CRPC. As may be noted, this is in addition of the requirement as provided under Section 51 of the CRPC. The purpose of inserting 50A of the CRPC, making it obligatory on a person making arrest to inform about the arrest to the friends, relative, or person nominated by the arrested person is to ensure that they would able to take immediate and prompt action to secure the release of the arrested person as permissible under the law. The arrested person, because of his detention.
Okay, Mr. Sering, show me the order of the magistrate that day.
My lord.
On 19. You
Page
surrendered on 19.
My lord, page number 74, my lord. May I read, my lord? The accused, Sri Tabing Lamgu, has been produced before this court following his arrest in connection with the present case. Upon reviewing the case records, it is noted that Sri Tabing Lamgu is a wanted individual in this matter and a proclamation has already been issued against him. The accused voluntarily surrendered to the police station on 19/3/2025 and was formally arrested, my lord. The accused has been heard and the case record have been thoroughly examined, including the medical report, arrest cum inspection memo, the accused challan, and the forwarding letter. The medical report indicates that the accused is suffering from non-reconstructible Buerger's disease, peripheral arterial disease, and other related condition. The attending doctor has recommended that a board of doctors assess and certify the accused fitness for the police remand. In the light of the medical condition, the investigating officer is directed to obtain a fitness certificate from the board of doctors at the district hospital Sepa and produce the accused before the court for further proceeding, my lord. Now, thereafter, if I may take my lord to page number 77. This is the observation of the board of doctors, my lord. In pursuance of order number so and so, the medical board examination of Sri Tabing Lamgu at District Hospital Sepa has been constituted and the finding and recommendations are as follows. Post amputation of right great toe with transpolicial embolectomy of right.
Okay, he's suffering from certain ailments. Then
Not to be
what
fit,
happened?
not fit to be kept in the custody.
Then
Now,
what
my lord, for a time being, my lord, if I may take my lord to this, the previous judgment, the last observation, my lord, I may be allowed to highlight that.
Then he went to Delhi without the order of the magistrate. My
My
lord
lord,
is correct.
the judgment, last
No,
part, my lord.
then what happened? He is still in police custody.
Yes, my lord.
He is
No,
in
no,
Delhi.
Officially, he is in police custody, my lord.
No. The police custody on 24, there was a prayer for
Then
police
where is
custody
the
for
release order, my lord?
3 days. Your
If he is
Lordship.
not in custody,
Absolutely, that's the
where is the
point.
release order? If he is not in police custody, there must be a release order then. So where is the release order?
He is absconding. He is absconded.
Now
from
thereafter,
trial.
my lord, he has been referred to trims, my lord. If I may take my lord to page number
Currently, he is in Delhi,
77, my lord. 79, my lord.
This is discharge.
Discharge slip, my lord. And in this case, my lord, he has been referred to Vedanta Hospital, Delhi for stem cell therapy, my lord.
And he went. On the 21st,
Then-
by the
then
Donipur
where is he, my
Express,
lord?
he went to Delhi.
No, he did not
Is
go to
that-
Delhi yet.
Is he in Delhi or not, my lord? My friend has to say yes or no. He is currently in Delhi.
Your Lordship.
Officially, my lord, he is still in custody.
No, Your Lordship.
And-
That's an absolutely wrong
Then-
summation. If I may take.
Then
Your
where is
Lordship-
the release order then?
Yes,
Where is he now?
he is in Delhi. He's in Delhi.
How he went to Delhi?
Absolutely, that's the question that is being put out by the complainant, Your Lordship.
Who dictating that he's in Delhi, my lord?
My submission is.
From
Your
where they are
Lordship,
making this
I will
submission?
just
don't
make
know,
a
my lord.
submission, Your Lordship, because the ticket has been given to the IO, Your Lordship. That's what I was placing, Your Lordship. His statement as well as tickets are not on the record.
No,
Therefore, I was taking.
If he surrendered before police,
Yes.
then police allowed him to go to Delhi.
Absolutely, that's the point they are making out, and the
Where is
order,
the order,
order
ma'am?
has just come out today morning. That is on 24/3/2025. Your Lordship will see.
Show me the order.
Yes, I have annexed it along with the CD, Your Lordship.
My colleague has also given a copy, my lord.
Your Lordship will see the date of the order is 24/3/2025. That is today's order. CD ka dekho. I have flagged marked with Your Lordship orange color.
Bail comment.
Yes, no, Your Lordship. दे तो CD में वो जो flag mark करके रखा है.
This is bail comment.
Order is dated 24. No, prior to bail comment, Your Lordship, there must be.
My colleague has also given a copy of the same order, my lord.
If I may read, your lordship, that is of today's date. The accused so-and-so was produced before the executive magistrate on 19/3/25 with a prayer to remand the accused under police custody for a period of 3 days. There was a prayer for remand of the accused for 3 days, your lordship. Upon perusal of the case record, it is found that on 19/3/25, I of the case was prayed for police remand of the accused Tabing Lambu before the executive magistrate SEPA. But as per the medical report of the accused, he was suffering from the non-constructible so-and-so disease, peripheral arterial disease, and other related condition. Therefore, the executive magistrate has directed the IO to obtain a fitness certificate from the board of directors of district hospital SEPA to enable him to address his prayer. Accordingly, a medical board was constituted and they declared the accused unfit to be kept under the custody and recommended him to TRIMS for further treatment. On 23/2024, the IO had submitted intimation letter wherein he stated that the accused was admitted in TRIMS for further treatment. And on 23/2025, the doctor who was attending the accused at TRIM has again referred the accused to Medanta Hospital, Delhi for stem cell therapy. Hence, the accused left for stem cell therapy, your lordship. Based on the report of the doctors and the IO, the accused required his treatment and he is not fit to be remanded under custody. Since the prayer was made for 3 days of police custody, the same was rejected only on his health ground, your lordship. However, there is a reflection that he has already left Delhi for the stem cell therapy. And therefore, my submission, my prayer before this court was at least those things has to be kept, be available in the CD, your lordship. The statement, because in the bail comment, there is a statement that he has already given a statement.
Magistrate says that he cannot be remanded to custody.
Yes, madam.
Police custody, yes.
Where he is now?
He's in Delhi, your lordship.
He left for Delhi on the 21st.
He is
my
in
lord.
judicial
He
custody.
seems to have a
He's-
better idea of the
No,
alleged
no, my
accused,
lord,
my
he's not
No,
in
no, no,
judicial
no.
custody. He's
Your
not in
lordship,
I have been
therefore,
informed by the
let me at least
brother
make a
that he
fair
is in transit.
submission, your
madam.
lordship.
He is at Guwahati right now.
He-
I have been informed that.
Let
The
me
order
be fair
says
with
he
the
left.
submission, your lordship.
The order says he left.
My only, sir, please. My only thing is that since there is there was a direction by the court before whom the accused has surrendered on 19 that first you go for medical checkup, there, whatever the report be, you come to the court, will issue an order. That is how the remand process happens, your lordship. There, in between, there is no order except for the order of today, your lordship. Now, this magistrate says that there was a prayer of 3-day police remand.
That was not granted.
That was not granted. He is still under judicial custody, your lordship. However, unfortunately, your lordship will see the line that has been reflected in the order is that hence the accused left Delhi for cell therapy, your lordship. Now, this point has to be taken into consideration in the CD. That's
my
my
lord,
fairest
Since
commission
I
be
am,
given.
my lord, on number one on humanitarian ground, if I am not fit to be kept in custody, my lord, I should be released on bail, my lord.
That these documents show that you are not in police custody or in judicial custody.
Yes.
But since officially I'm still into custody, my lord. I was arrested
And
on
if he's not in custody, then
19/3/2025.
this bail becomes
But my lord,
infructuous.
keeping this discussion apart, my lord, this submission apart, my lord, since I am not fit to be kept in the custody, since my statement has been recorded twice on 19/3/2025 and initially when interim was granted in anticipatory bail application. But on humanitarian ground, I can be released on bail, my lord. And the
He's not
second
in
part, my
custody,
lord,
my lord.
if my lord may allow me to complete this judgment, my lord, I'll justify one more thing from here.
Which one?
The last part, my lord, the judgment. Vihan Kumar, my lord. The last page, my lord.
I have read this.
I'll read from third paragraph once, my lord. Therefore, the purpose of communicating the grounds of arrest to the detainee, and in addition to his relative as mentioned above, is not merely a formality, but to enable the detained person to know the reason for his arrest, but also to provide the necessary opportunity to him through his relative friends or nominated person to secure his release at the earliest possible opportunity for actualizing the fundamental right to liberty and life as guaranteed under Article 21 of the Constitution. Hence, the requirement of communicating the grounds of arrest in writing, my lord, is not only to the arrested person, but also to the friends.
I have read it 7 times. He has gone to Delhi. Maybe he has taken by police.
Yes,
No, my lord, he's
was
not.
no. My statement. Therefore, I had asked the IO to at least provide me that in the CD. Therefore, my instruction is that he had booked his ticket himself, your lordship. The police assisted him only through the railway station, Your Lordship. There is no one present in the Medanta hospital. That has been informed to me, Your Lordship. There was also a suggestion from me that there has to be someone along with the accused. There is no one. The police escorted him only through the railway station, Your Lordship. And therefore, this order was sent to me via WhatsApp, Your Lordship, the date 24/3/25, where it clearly says, and therefore I had asked the OCO, IO also to at least get me the train ticket that they have produced before the IO, and the statement that he has recorded his statement as given in the bail comment, Your Lordship. These are the two documents
I have
that we
not
need.
run away from the custody, my lord. There's no allegation of running away from the custody.
No, I'm making that
They
allegation.
insist
my lord,
there's a
I'm sorry.
direction to go for an operation, my lord. That is the
A
reason
post facto
I'm at
direction.
Guwahati at the moment.
Direction
And since I'm
comes on
not
the
fit to be kept in a
24th,
custody,
released
my
on the
lord,
21st.
since my
My
statement
lord,
has already
please.
been recorded. And moreover, my lord, I'm a practicing lawyer. I have my whole career here, my lord. There's
So,
no
my lord, the
flight risk
Supreme
also,
Court
my
has
lord.
dismissed his anticipatory
Therefore,
bail
my
on
lord,
this.
at this
Please.
stage, my lord, my bail may be considered, my
No,
lord, considering all the
please hear me.
suspects.
Please
Now
hear
he's
me for
making
a
a
minute.
submission. I don't know, my lord, how many lawyers they have.
Let me make a submission. My friend is, my
Why you are
friend for
making
some
submission?
reason
You are in,
doesn't.
make one submission.
Let me make a submission. Let me make a submission.
How many
Please.
lawyers do you have?
Let me make
There's
a
no notice
submission.
also.
My friend will allow me, I am also a lawyer. My friend will allow me to make a submission, that is all. My submission is this. My lord, section 187 is categoric that a magistrate, subsection 5, for the avoidance of doubts, it is hereby declared that notwithstanding the expiry of period specified in subsection 3, the accused shall be detained in custody so long as he does not furnish bail. 187 subsection 5 explanation 1. Now this has to be read with section 480 BNSS. The JMIC and the CGM have no authority to give bail in a case where death or imprisonment of life exists. That can only be done by the Honorable Sessions Court or the High Court. 187 subsection 5 explanation 1 read with section 480 of the BNSS.
He is imputing all the allegation against the prosecution, my lord, not against me.
No, he's a powerful person. That is why the prosecution seems to be helping him. As a I'm beseeching the Constitutional Court to ask for a report. How did this happen? We
Show
all
us
have
the
to follow
authority.
the law, my
Show
lord.
us the authority on what basis you are making this submission.
Yeah, I'll show everything, my lord.
Show it now.
1875.
Show it now.
480 also, my lord. Section 480.
But there's a very good ground, my lord. I'm seriously ill, my lord. And even there's a clear observation of the board that I'm not fit to be kept in custody, my lord. My statement has been recorded twice, my lord. At least at this stage, my lord, I deserve a bail, my lord.
480 clarifies this. Bail can only be granted by the Sessions Court or the High Court if there is a case involving death or imprisonment for life, which 302 is. How has this man gone, my lords?
My humble prayer, Your Lordship. Yes, because all the allegation has been put against the prosecution. The prosecution seeks time to furnish some more documents. That's the only prayer, Your Lordship.
Day after tomorrow, we'll pass down.
Yes,
How-
Your Lordship.
How do you reserve?
Reserve. Obliged.
Deeply obliged.
Can we give written submissions, my lords, please?
Yes.
Can we give a short written submission to assist the court?
Do you have any authority, brother?
Before we have to file it tomorrow.
Yes, by tomorrow. I'll file it by tomorrow. Yes, my lord, by tomorrow.
Obliged, my lord.
Number 21, 22.
Yes,
Your Lordship.
yes.
Your Lordship, the petitioner seeks to withdraw the case with liberty to file fresh.
You want to withdraw it?
Yes, Your Lordship.
Okay, what is your name?
Your Lordship.
What is your name?
C. Bangsia.
The learned heard MS so and so appearing for the petitioner. Heard
Opada, my lord.
Opada.
For respondent number 5, in item number
For respondent
21
number
and
5.
22, item number 4. Respondent number 4.
22. You want to withdraw 22 also?
Yes, Your Lordship, both.
In item number 22, he will be Opada is for Respondent number 2.
No, four, my lord.
Respondent number 4. And for others, your,
Lordship, I put applicant in IS 10 of 2020.
no, in item number 21, your respondent number what?
I number 10.
Huh?
For applicant in I number 10.
Item number 10.
Yes, I 10.
No, in.
Item number 21, I number.
No, in the read petition?
In the read petition, I'm not.
31, my lord.
MS so-and-so submits that she has, yes. MS so-and-so appearing for respondents, 2, 3. MS so-and-so appearing for the petitioner submits that she has instructions to withdraw this writ petition with a liberty to file it afresh. But after hearing both sides, the prayer is allowed. The writ petition stands disposed of for withdrawal. Liberty is granted to file it afresh. The same order in item number 22 also.
My lord. Obliged.
Yes, my lord, this is appeal, it's a 23, yes, your lordship. It's a POCSO matter, your lordship. We have been directed to take steps, your lordship. However, we have received the report from the concerned officer in charge, but your lordship, not the duly acknowledged by the victim. So what my humble prayer before your lordship is, your lordship may kindly grant us further time so that we'll serve the notice again through OC to the victim, your lordship.
Mr. T. Attendant Principal Police Prosecutor submits that a notice upon the respondent number 2 could not be served. And therefore he prays for some more time so that the notice upon the respondent number 2 could be served.
Yes.
By the concerned police station.
Yes, your lordship.
The prayer of Mr. Ate is allowed. At least after 4 weeks.
Yes, your lordship. Deeply obliged.
For orders.
Yeah.
May it please, your lordship.
Yes.
This is an application for restoration of a regular first appeal. Unfortunately, it was dismissed for.
Dismissed.
Yes, your lordship. In fact, there was an interim order also operating, but unfortunately, we've not been able to appear. The lordship will come to pace.
Do you have objection?
Yes, my lord, it seems that there is willful disobedience of this honorable court order. So therefore, my lord, I may be allowed to file affidavit, my lord. There was an order. Yes, my lord.
So difficult. A. Sharma.
A. Sharma.
So the only difficulty is they are proceeding in the execution case, and in this particular trial in the lower court, we're not even able given the right to defend this case.
My lord.
I will state the execution proceeding.
Yes.
Mr. S. Sharma.
A. Sharma, lordship.
A. Sharma.
If I may just give the execution.
Appearing for the petitioner. Heard, Mr.
Arriva, my lord.
Appearing for the sole respondent.
Yes, my lord.
Sole respondent.
The learned counsel for the sole respondent prays for some time.
My lord,
an objection.
Original appeal petition may be also, sir. My
copy of the application shall be provided to the sole respondent. Then Mr. Sharma submits that the other party has been proceeding with the execution of the impugned judgment. And if the decree is executed, the present appeal will become infructuous.
Yes, your lordship.
After considering the submissions made by the learned counsels of both sides, it is hereby directed that until further order, the further proceedings of execution case number 06 of 2024, pending in the court of, where it is pending?
Pasighat.
Civil Justice
Senior
Division.
Division.
Pasighat shall remain stayed.
Oblige, your lordship.
List after 3 weeks.
Oblige.
much of
25. Yes.
This case is lordship against this interim compensation order passed by the judicial magistrate first class in connection with check bounce case.
Okay.
Kindly see, may I take your lordship to last order passed by the judicial magistrate, page number 45 of the petition,
Yes.
annexure 3. In this case, operative portion I'm reading. Learned counsel, the defense counsel, Tapak submits that there is no legally enforceable liability of the accused towards the complainant. However, the said check in question was in fact issued by the accused person as a security check on behalf of one Morgan Omdir. And the check amount was in fact to be ultimately paid by the Morgan Omdir to the complainant, as thus he submits that there is no liability of the accused to the complainant. The prayer for the interim compensation should not be allowed. Even then, Lordship, this order has been passed. Before this order to pass, in a background.
You see, Mr. Tapak,
Yes.
the security check bounce is also a NIACT case nowadays.
Yes, that is NIA case. But Lordship, may I take you, before that, may I take you, Lordship, to page number 42. This is the agreement on the basis of which check has been issued. Kindly see. This operative. Yeah, not that, page number 34.
34.
And yes, 34. Page number 34 is the agreement. As per this agreement, in a operative portion part is third paragraph. As per the third paragraph, there was a three party. One is Morgan Omdir and the complainant and the accused person. Accused person was a guarantor. There was a two guarantor in the case. At the time of this agreement, this entering agreement, there was as per the two guarantor, there was a plot of land to be discharged with that liability in question. Actually, that was not the fact. The fact was that kindly see in the page number 34, last paragraph, I Sri Likapada. This is one of the guarantors, and I am one of the guarantor in the case. Sergeant Sir's address and Sri Balwa Satta, this is the petitioner. Sergeant Sir's address.
Who issued the check?
Check, I have issued the check, and my partner, this given this.
Because in NIACT case, guarantors have no standing here. The man who issued the check,
yes,
he is the main party.
Yes, that is there. But as per this agreement, kindly see, there is an agreement. My agreement was up to the January. This as per the January, the money was supposed to be paid by there was some financial, some business connection in between the complainant and this one third person, that is Morgan Omdir. In this case, as per this last one, the operative person, if he fails to repay Morgan Omdir, Mr. Morgan Omdir, if he fails to repay the amount to the second party within 18 January 2023, he will be responsible to refund the amount. That is why this check has been issued. So what had happened, as per the Lordship, when this check was a security check, and my partner was standing on behalf of this third party, that was not a party in the NIACT proceeding. And as per the agreement, this proceeding was not as per this agreement. And this security check was to discuss just up to that point of time, up to January 18th. He took a responsibility to discuss the matter, to settle the financial disputes.
Your Lordship, the service is yet to be completed. Since this is not a joint petition, Your Lordship. Service awaited on.
Oh, notice not served.
This is not for setting aside.
It has not.
This is for just stay, and proceeding will be going on there. As per this,
notice upon a respondent number 2 has to be served.
Yes.
That is here why Lordship tomorrow matter is fixed in the judicial magistrate first class.
No
and there will be some compelling process maybe drawn against me. In that situation, this case will be infructuous, Lordship.
No, stay order you will not get.
Lordship,
Because, there is nothing wrong in the order.
I'm citing some court citations, Lordship. There are numerous judgment in which under section 143A of this NIA to
No,
pass compensatory order.
You will not get in a stay order unilaterally because the respondent number 2 has to come.
Yes, Your Lordship.
You have to wait.
So, can I publish his name in the newspaper, Lordship?
Yes, you can do
Yes,
so.
that may be allowed, Lordship. Otherwise, he will not come.
Okay. Heard Mr. T. Tapak, appearing for the petitioner, heard Mr. T. Gini, the learned to defend public prosecutor for the state of Assam. The notice of the respondent number 2 is not yet service of notice of the respondent number 2 is not yet complete. Para. The petitioner is directed to publish the
Your Lordship,
notice
if
after respondent number 2.
If I may, Your Lordship, if otherwise he can take steps through the PP's office, Your Lordship, because publication of the newspaper is the last resort, and more particularly in civil matters, Your Lordship. In criminal matter, either the police or the judge, the magistrate has to publish
No,
it.
he wants to publish the notice, let him publish.
Otherwise, the notice may go through us, Your Lordship. Go to us or
I'm bearing the
office.
cost.
Oh, you are ready to bear the cost.
I'm bearing
Let him publish them. The petitioner is directed to publish the notice upon the respondent number 2 in a local newspaper. Asking the petitioner, asking the second petitioner to appear before this court on tenth of April. So list this matter on 11th April.
11th.
So before 10th April, you publish it.
Your Lordship, while publishing, there has to be steps taken from the registry and then publication, Your Lordship. There has to be steps taken through the registry for publication. Bearing his own cost.
In that line, steps shall be taken to the registry.
Bearing his own cost, Your Lordship.
Yes.
The cost of the publications.
And at his own cost.
Yes, Your Lordship. Deeply aware.
Number 26.
Yes.
My lord, this is regarding the crossing of FIR and charge sheet of Banodra PS case number 27 of 2015, section under section 447, 448, and 427 IPC, read with section 3 PDPP Act, which was culminated
Government building was damaged.
Yes. One of the PCR was last time called for because FIR was not in the petition. FIR content was not available.
Who lost the FIR? Director of Land Management.
No, my lord, that is not direct.
No, where is the FIR? Show me the FIR.
PCR was called for. My
No,
lord,
in the record, you have.
FIR has been lodged by the petition number 7, the Junior Engineer PWD Division, Bandardoa.
No, you have not annexed the FIR here.
Yes, my lord. That is why, since the documents which the charges which I obtained, that FIR was missing, and that is why this honorable court has called for the PCR.
I remember it. So, respondent number 7.
Yes, my lord. Junior Engineer.
What is his name?
Yoram Yomdik Thomas.
Yoram Thomas.
Yes.
Thomas.
Yes.
Illegally dismantling and demolishing a government property. Why he wants to compromise?
My lord, it was the complainant says that the government property has been damaged. The petitioner says that he has the allotment, he has allotted there was no trespass, no damaging of any other property, but whatever was just clearance of a scrub within the then premises of allotted land of the petitioner. The allotment, my lord, allotment is annexure as annexure A, that is in page number the page number 31, my lord.
Government property was damaged.
This was the land allotment under which the complaint was made. This was the property, this was the allotment allotted to petitioner number 3.
But the man who lost the affair, he is not
He is the junior engineer.
competent to compromise the matter.
My lord, in this connection, I would like to state that the Honorable High Court has directed the Deputy Commissioner to decide the matter in favor of the petitioner. That order is in
Page number 49.
that order is in
Page 54, Lordship.
page number 54. And on this basis of the High Court order, Deputy Commissioner has summoned both the parties and finally settled the matter as per the High Court order.
Oh.
And so Deputy Commissioner has summoned both the parties and they have settled the matter. And on the basis of this settlement, amicable settlement agreement was entered between two parties, accused and complainant. Now both.
Okay, what do you want to say?
Lordship, as per the record, Lordship, this matter is already been resolved by the Deputy Commissioner as the direction made by the Honorable Court, Lordship. Though it may be liable to be
Cost.
Obliged, Lordship.
Most obliged.
I asked
For condonation of delay.
notice of the.
My lord,
Yes.
I filed affidavit.
You have filed affidavit.
Yes.
There are 3 respondents. I am representing respondent number 1.
What about 2 and 3?
One is the claimant, is the necessary party.
You are for the insurance company.
Yes, I am for the insurance.
So you are for respondent number 1.
Yes, ma'am.
What about 2 and 3? Notice of the note.
No, sir, no, notice, not served.
I think a step has not been taken.
You delete these 2 names.
No, Lordship.
You delete these 2 names, 2 and 3.
No steps has been taken for 2 and 3. Since it was listed on motion and since there was a caveat file, caveat, so it's listed.
Now, if you want these 2 persons,
Yes,
you have to serve notice upon them
definitely.
because they are in the cause list, cause title. Right, Mister?
ठीक है, Lordship, but Lordship, this condonation may kindly be considered since they have, after the award was granted, they have filed an execution petition before the tribunal. Now, because of that execution petition, the company, they are directing the company to make the payment. So if if it is not stayed, then it will be, the appeal will become infructuous.
My lord, the first applicant may be directed to take step. Thereafter, we may have hearing on the condemnation petition.
Heard Mr. Soitse appearing for a petition. Heard Mr.
S. Cohen.
Appearing for the respondent number 1. Yeah, have you filed an objection?
My lord,
Yes, they have filed objection.
yes, ma'am. I filed reply also.
It is in a record or not? It is in a record.
Yeah, Lordship, I have just received the copy.
The petitioner, the respondent number 1 has filed an objection. And the learned counsel for the petitioner has received the copy of the same. Where it may be stated that the said objection is not available in the record. Therefore, registry is directed to tag the said objection with this record. There, the petitioner is also directed to take steps for service of notice upon the respondents 2 and 3 by registered post it area. This after 4 weeks.
Lordship, 2 weeks, Lordship. Otherwise, this
4 weeks,
After 2 weeks.
that is, I think,
Let us
4 weeks
argue-
appropriate because, the people, respondent
Lordship, I will
was,
take steps with-
respondent number 2 and 3, they are from Assam. They are from Assam, so within 4 weeks is
Lordship,
necessary.
let them decide. I will take steps within 2 days. If it's after 2 weeks, accordingly. Lordship.
No, make it 4 weeks.
4 weeks,
Before that, it will not come if they are in Assam. You have to take immediate steps. Within 1 or 2 days, you take steps, then those things will come back. Otherwise, it will not come.
Okay.
Number 28 or 29.
Yes, I is for her.
Lordship, I is for passing status quo anti order.
Watching.
Not passing Lordship. Kindly to page number
No, status quo order was given.
Lordship.
No, my lord.
Earlier, my Lordship. In this case, Lordship, this court below.
No, you want status quo.
Yes.
He wants a status quo.
District judges pass an order directly.
But he has claimed that I am doing some activities on the disputed plot of land. Let me take instructions, my lord, whether really they are really doing it.
Status quo order will be passed, Lordship. Otherwise.
Let him take instructions first.
I will take instructions first.
How does it treat upon? Appearing for a petition? How does it deep again? Appearing for the. Appearing for the. Sole respondent.
Yes.
Mr. Panging submits that he needs some time to take inspections in respect of the claims made by the petitioner. After hearing the choice, his prayer is allowed. Next Tuesday,
Man.
listen next Tuesday.
Observation will be made, particular date may be fixed.
Next
Observation may-
Tuesday,
On next Tuesday,
Yes.
give the date.
For hearing of the interim order.
On the next date.
we can hear the main matter also.
Oh, yeah.
I am ready.
On the same.
I am ready now.
Tempering the notice. This is the
Okay,
hearing.
on the next date, an endeavor shall be made to dispose of the matter. Yes.
This is, business application.
So that matter.
Minor. For my modification, alteration and correction of the order passed on 9/3/2025, my lord. My lord, annexure C is the, my lord, order.
State officer, explanation from state officer.
Yes,
Reply from, you want reply from state officer.
reply
No, no,
from state officer as well as deputy commissioner.
The order.
Yes, my.
What do you say?
Your lordship,
What do you
I'm
reply?
preparing for 4, 5 and 6, your lordship. In men,
4, 5 and 6, that is state officer.
yes, your lordship.
And you are for?
Health department.
Hmm?
Health department laws.
You are for 1, 2.
Yes, yes, no.
1, 2 and 3.
2 and 3 first.
2 and 3. Who is for 1?
One is land department, your lordship.
Land.
Land management.
How do you say T son? Appearing for the
Sorry for interrupting, my lord.
petitioner.
My lord, can you pay, peruse this, my paragraph 3, my lord.
Okay. Heard, Mr. What is your name?
Lordship, I'm appearing on behalf of
Okay, no,
Senior Standing Counsel.
What is your name?
T Tato.
Appearing for the respondents?
2 and 3. Yes, lordship.
Appearing for the respondents 2 and 3. Heard MS? What is your name?
P Sangeeta, your lordship.
Appearing for respondents 4, 5 and 6.
4, 5 and 6.
Issue notice. No formal notice is required to be sent to the respondents 2, 3, 4, 5, 6. As because the learned councils have accepted notice, extra copy of the petition shall be provided to them. The petitioner shall take steps for service of notice of the respondent number 1 and 7 by registered post it area. Least after 4 weeks. till eternal date, what stay order you want? So called notice.
Can you page 9 or 10, man? Here, some portions were missing from the that.
Okay, all right. Where have you mentioned?
Further, it is a 10, man, page 10. Further, it is directed that the respondent number 4, 5 shall dispose of all the pending so-called replies
Yes, sir.
submitted by the petitioner along with the
Okay,
appeal.
all right. It is a list after 4 weeks. It is hereby directed that the respondents 4 and 5.
Yes, ma'am.
Shall dispose of all the pending so-called replies.
Yes.
Submitted by the present petitioner along with the appeal number 02 of 2025 as expeditiously as possible. Before the next date of listing.
And thereafter, madam, till further returnable date, the interim order shall be considered in the next day.
On the next date of listing, the prayer for interim order prayer for interim order shall be considered.
Much of that.
Yes, I have to what?
My lord, this is an application for continuation of delay of 134 days, my lord.
Then now notice will go. Hard, Mr.
Mukbang. At this stage, what we're praying for is that notice may serve to respondents.
Hard, Mr. So appearing for the petitioner. Issue notice to the respondents. The petitioner shall take steps for service of notice upon the respondent by registered post AD.
My lord, by a dusty mode, because there's an urgency.
The petitioner shall take steps for service of notice upon the respondents by dusty. After service of notice, the necessary affidavit shall be filed. How much time do you need?
1 week, my lord.
1 week?
Within 1 week, it may be listed.
It will be completed.
Yes, my lord. Then residing in the same villages.
Okay. Then list next week.
Much obliged, my lord.
33. Yes.
Your Lordship, here also the petitioners seeks to withdraw the matter as the matter has become infructuous.
Infructuous.
Yes, Your Lordship.
The learned counsel MS so-and-so appearing for the petitioners has submitted that the present writ petition has become infructuous and therefore she wants to withdraw the same. I have also heard MS
P. Sangeeta,
appearing for all the respondents.
Yes, Your Lordship.
Appearing for all the respondents. The prayer of the learned counsel for the petitioners is allowed. The writ petition stands disposed of on withdrawal.
Obliged.
Well, not possible today. I have been struggling to argue this case for last 1.5 weeks, my lord. So finally, my younger sister is also leaving on a holiday tomorrow.
Yeah.
So we have arrived to a conclusion that Mr. Tado, K. Tado, additional PP would be appearing. So, my lord, kindly list this matter after the motion column. Wednesday, I will start my argument for 40 minutes.
Next Wednesday. This Wednesday.
This Wednesday.
This Wednesday will not be possible because Thursday will be my last day.
Oh, no, Wednesday, I start. I'll take only 40 minutes because the conviction is only on the basis of the statement of the prosecutrix without any corroboration.
You do it on some other day.
Kindly accommodate because my client has been crying. I'll take not more than 30 to 40 minutes.
2nd of otherwise April, Your Lordship. 2nd of April.
2nd of April.
Or my lord, no, kindly accommodate me on Wednesday. Then
because next day will be my last day.
No problem.
Otherwise, it will remain.
Wednesday, Tomorrow is Tuesday.
If it remains CAB, it may take some time.
No problem. I want to finish it because the client is present.
Okay,
Wednesday.
Hearing the learned counsel of both sides, the hearing is adjourned today, list next Wednesday.
Wednesday after motion call.
List next Wednesday after the motion column.
Much obliged.
Okay.
So this is also a hearing matter.
We do it on some other day.
Next Wednesday.
Uh,
Next Wednesday.
Next Wednesday. This Wednesday or
Next.
next. After hearing the learned counsels of both sides, hearing is adjourned today. Next Wednesday, not this Wednesday.
Yes.
Next week Wednesday.
Next.
For hearing.
Like. Next week.
Number 39 for the drugs. You want to withdraw it?
May I, Lordship?
You want to withdraw it?
Yes, Lordship.
MS so and so. What is your name?
Margam Basir.
Agam Base.
Yes, Lordship.
Preparing for the petitioner submits that she has instructions to withdraw this writ petition. On the basis of the submission made by the learned counsel, the writ petition stands disposed of on withdrawal.
Much obliged.
Thank you.